Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. More than 8 hours of argument time has been requested. We won't be able to accommodate that. Remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We read your papers and are familiar with the issues that underlie your appeals. Those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Alexis Sanchez, submitted. Kunz v. Cedric Y. Yes? 5 and 2 and 5. Wilmington Savings Fund v. Okono. Appears you don't have an opponent today. Oh, sorry, counsel. I'll give you 3 and 1 and 3. People v. Michael Antoine, submitted. Andrade v. 1203 East New York Avenue. The 4 and 1 and 4. CSN Realty Corp v. Musf. Five and 2 and 5. People v. Christian Gonzalez will be hearing the argument on both indictments. Submitted. Mcom Estates v. CMB Export Infrastructure. Four and 2 and 4. Blumenfeld v. Smith. Five and 2 and 5. Perez v. Q Gardens Development. Have you seen your opponent? Would you like to address the court? 2 minutes it is. If he or she comes, we'll deal with that if it happens. Okay. OCF Brook Holdings v. Sprung. Okay, I'll give you 6 and 2 and 4 and 3. Paro Management v. Allied World National.
Standing beside me is Tishman from the Bar of Illinois. Will the court allow him to argue today?
Granted.
Thank you, Your Honor.
Mark Subcheck for appellant, 6 and 1, please. For the respondent, every court's 5 minutes.
4 and 2 and 4. Thesuza v. Hudson Yard Construction. Four and 2 and 2. Thechecko v. Tishman Construction Corp. 4 and 2 and 4. Hoben v. FCA US LLC. There are 3 appellants.
Good afternoon, Your Honor.
Granted. 4 and 1. Okay, 4 and 1, 4 and 1, 4 and 1, and 10. Blue River v. Gross, Justice Hagler is recused on that case.
Responding Gross, 5 minutes, please.
4 and 2 and 4. People v. Francis Ramirez, submitted. Okay, first case up is Kunz v. Cedric Y. Please.
Good afternoon, and may it please the court. My name is Jessica Hallam with Mental Hygiene Legal Service for Appellant Cedric Y. Mr. Y is a 74-year-old man with no history of psychiatric diagnosis or treatment. And yet last July, he was court-ordered to be forcibly treated with 9 antipsychotics and benzodiazepines and infinite medications and treatments for side effects. The order was granted on the 3rd treatment over
Now,
objection.
the prior denials were, of course, denied without prejudice.
Yes.
And wasn't there sufficient evidence here to show that this was correctly granted?
No, Your Honor. So Kirby was required to establish by clear and convincing evidence that Mr. Y lacked capacity to make reasoned treatment decisions.
Was the ideation of sexual contact by staff sufficient to allow for the order?
No, Kirby failed to present any evidence about how that would affect his treatment decisions, and also Mr. Y testified that he was inappropriately touched by a peer and was mocked when he reported it to his treating physician. So it's unclear whether the allegation of a sexual delusion is true.
So to the extent that the diagnosis to date is unspecified schizophrenia with consideration of delusional disorder, doesn't the perception of sexual persecution represent an escalation in some way?
No, Your Honor. It is an allegation of an additional behavior, but the hospital was required to connect that to Mr. Y's decision-making abilities, and it failed to produce any testimony about why Mr. Y's concerns about inappropriate touching affect his ability to make treatment
So
decisions.
with respect to the 2 earlier denials, was there any indication that the patient threatened the use of violence, or was this the first time?
Not in the first 2 hearings, and also the record does not reflect that Mr. Y actually threatened any staff or peers.
What was his language, counsel?
His language was that he discussed not knowing what to do, and he asked his treatment provider what to do with these experiences that he was having on the unit. And as the doctor testified, Mr. Y has never harmed anyone on the unit. As in the first 2 hearings, Kirby failed to establish its burden in the hearing below. It argues that Mr. Y lacks capacity because he was diagnosed with a mental illness and disagrees with that diagnosis. However,
Just bringing you back, didn't your client say that he would have to fight back against the doctors in his claim about his inappropriate touching?
Dr. Straka testified that that was language that Mr. Y used. However, it was connected to his he was talking about how he did not know how to handle the situation. He did not say that he indicated that he wanted to use violence against other staff or peers. He was simply trying to get across that he did not know what to do.
I don't understand your answer before then when you said that there was no threat of violence, that no language had been used. The language "fight back" as against the doctors and the staff, as my colleague indicated, can that not be considered a threat?
That could be considered a threat, Your Honor, if it were directed at someone.
So when you answer a question in the future, please be a little bit more forthcoming, because you simply said no.
Okay.
Counsel, did your client ever accept that he has a mental health diagnosis?
No, he has consistently held that he has not accepted that, but that is not enough to establish a lack of capacity. As the Court of Appeals indicated in Rivers, mental illness often strikes limited areas of functioning, such as capacity is intact.
Counsel, how do you address the new delusions with regard to Dr. Kroll, where he was allegedly harassing and threatening? That was new prior to the last two hearings.
With regard to the harassment and threats, much of that information is not actually in the record. However, that is a continuation, I see.
Please continue.
That is a continuation of a pre-existing belief that Mr. Y has held since the beginning of his hospitalization and perhaps longer. It is not evidence of an escalation. He has been following, as the doctor testified, this physician for years. And so this is not new information. It is just a continuation of a pre-existing belief that does not affect his ability to make treatment decisions.
Thank you, Counsel. You have time in rebuttal.
Can you address Dr. Kroll, because the light went off, and I'll have a question in rebuttal. I thought that the record reflects that there was an increased harassing and threatening behavior that did not occur in the prior two hearings.
That is exactly right, Your Honor. So on pages 36 and 37 of the record, Dr. Straka expressly testifies that this Dr. Kroll harassment is new. It escalated to the point where he even arranged for a friend to visit her office in person, and that friend had to be removed by security, which reflects the extreme extent to which these delusions have now manifested and are resulting in actual acts outside of Kirby that are harming other people.
Counsel, did you make your appearance? We may have jumped in.
I'm sorry, that's my fault.
Good afternoon, Your Honors, and may it please the court. Samantha Neal for the state respondent. This court should affirm the treatment order for two reasons. First, Cedric Y lacks capacity to reason about treatment decisions. The record establishes three significant changes in his condition since the prior petition. So first, his new reasons for refusing treatment are now grounded in delusions. For example, he's now refusing treatment because he falsely believes that his treatment team is trying to sedate him so that he can be raped. This is a fundamental misunderstanding of the reasons for treatment, and the new sexual and persecutory delusions are now impairing his capacity to even understand the condition that he has and to reason about treatment options.
Counsel, is this also the same argument that you're using for the res judicata issue that was brought up?
For the res judicata issue, yes, because under Leonard H.H., even a slight change of circumstances are enough to justify a new petition, and these new sexual and persecutory delusions are new, as Dr. Straka testified, and so, this does constitute more than a slight change of circumstances.
So, counsel, I'm sorry.
Your friend here referenced Rivers, and I'm curious as to what your take is as to that reference, because my understanding is that there the Court of Appeals said that the right to reject psychotropic drugs is not absolute.
That's right, Your Honor, and I'd also like to quote a quote from Rivers on page 495 of the opinion, where the court also said that where the patient presents a danger to himself or other members of society or engages in dangerous or potentially destructive conduct within the institution, the state may be warranted in administering antipsychotic medication over the patient's objections. So the right to reject treatment is not absolute. The state, under certain circumstances, may be justified to step in. This is one of those circumstances, given the extent of the danger that he poses, not only to himself but to others.
So, counsel, I was also exploring the alleged sexual delusions. wasn't there another facet to this delusion wherein prior there may have been patient allegations, but now it's spread to actually the staff? There's allegation that multiple members of the staff were sexually assaulting the patient when that never occurred. Isn't that a new fact as well?
So yes, the fact that he's now alleging that there is sexual harassment from others in the facility, other patients, as well as the treatment team, those are both new. And to address petitioner's claim that it hasn't been determined whether or not those allegations are true, I also want to note that at pages 34 and 35 of the record, Dr. Kroll expressly said that those allegations have been investigated and have determined to be false.
Did the doctor's testimony that the proposed, did the doctor testify that the medication outweighed the benefits of the medication outweighed the side effects, and that it was narrowly tailored to address his needs?
She did, Your Honor. On pages 41 through 45 of the record, she specifically addresses the narrow tailoring, confirms the treatment order is correct, and also explains why she chose clonazepam and risperidone as the primary antipsychotic medications based on his tolerance of those medications in the past. If there are no further questions, then I would ask this court to confirm the treatment order. Thank you.
Thank you, counsel.
I'd like to address the respondent's second point about the treatment over objection order being narrowly tailored. Even if Mr. Y does not have capacity, the hospital failed to prove that the treatment order was narrowly tailored. Rivers requires that this be established by clear and convincing evidence, including by taking into consideration all relevant circumstances, such as the benefits of treatment, potential side effects, less intrusive alternatives, and why the primary treatment was chosen over alternatives. That is not in the record here. Dr. Straka did not—
Has the patient refused all treatment?
I'm sorry, could you repeat that?
Has the patient refused all treatment or all medication?
He has refused treatment with all psychiatric medications. He has accepted treatment for medical conditions.
I'm sorry, I'm not hearing you. Can you say that again?
He has refused treatment for psychiatric conditions. He has accepted treatment for medical conditions. And Dr. Straka did not explain, contrary to respondent's argument, why she chose these medications. She named two medications, risperidone and clonazepam, and then moved on. Kirby presented no evidence about the risks or benefits of any of the 9 antipsychotics, benzodiazepines, or unlimited, unnamed medications and treatments for side effects. It's significant that this is Mr. Y's first time being diagnosed with a mental illness at the age of 74. This is a lot of medications to be allegedly curing what the doctors believe is a delusion. That needed to be narrowly tailored specifically to Mr. Y, and it was not. The testifying physician's conclusory statements that the benefits of treatment outweigh the risks and that the treatment is narrowly tailored are insufficient to meet the Rivers standard. Those are legal conclusions for the court to make after the hospital presents evidence about the risks, the benefits, the reasons the primary treatment was chosen over the alternatives, and the basis for its conclusions. Here, Kirby failed to— I see my time is up.
Finish the thought.
Here, Kirby failed to present any evidence at all about any of the 9 requested medications or the medications for side effects as required under Rivers, and the hospital failed to satisfy the second prong of the Rivers analysis, and so the order below must be reversed.
Thank you, counsel.
Thank
you both. Wilmington Savings Fund v. Priscilla and Nochese Okoronquo.
Counselor. I bet you have.
Please.
Good afternoon, Your Honors. May it please the Court. Daniel H. Richland, Richland & Falkowski, PLLC, attorneys for Wilmington Savings Fund in this case. This has an interesting procedural posture because the underlying original decision held that my client was entitled to an order of reference, substituted Wilmington Savings Fund for the original plaintiff, NS-194 LLC, and denied the lack of capacity argument that was raised for the first time in opposition to summary judgment.
Counsel, can you just move the mic closer to your mouth?
Of course. Is that better?
Yes.
Thank you. The respondent then moved to re-argue that decision after the order of reference was in effect and after that decision to essentially argue there's still a lack of capacity about the original plaintiff. We believe that the underlying order here is incorrect for 3 reasons. The first, and you now have a copy of Star 201 LLC versus Martinez, that decision is the underlying basis for how the Supreme Court here made its decision. And essentially it relied on a Queens County decision that's now been reversed pursuant to this appellate authority.
Counsel, before we even get there, did the defendant waive the capacity to sue argument?
Yes, they raised in their answer only lack of standing and didn't raise lack of capacity at all. It was raised for the first time in
No, those two are often conflated.
Yes, and they specifically said here that we lacked the note when we commenced. They did not mention at all that there was a lack of authority. The lack of authority issue is totally distinguishable and separate, yes. And then there's also the mootness aspect, that the motion to re-argue was made after the substitution had already occurred. So they were seeking to challenge the capacity of the original plaintiff, not the existing plaintiff to
So
continue.
your argument is basically that once you've been substituted, you've got standing, you've got capacity. It doesn't matter what your predecessor in interest status was.
By that point, yes, exactly. And then on top of that, the argument that they did raise regarding lack of capacity was essentially only evidenced by an ECF printout for NS 194 LLC, and unfortunately for the respondent, New York LLC Law 803 subsection A, subsection 1 excludes from the ambit of doing business the maintenance or defensive actions.
So one question in that regard, does the general acquisition of mortgages amount to doing business
No.
in New York?
There's case law from this department, I believe it's from 1947, that holds when you buy inventory, that does not constitute doing business. And buying and acquiring a note is basically acquiring inventory. In addition, the situs of the note would be dispositive with respect to where, in fact, that transaction occurred. So to the extent you're saying that there's an acquisition of a note generally, did that occur in New York? Did that occur in Texas? All of that burden was held by the respondent, and they didn't make any showing that this actually occurred in New York, that the note at the time of the acquisition was, in fact, in New York. Their argument they're making is that because it affects New York real property, therefore this plaintiff must be doing business. And that's just a deficient argument. It's not proper. I
Thank you,
apologize.
counsel. You have time to rebuttal.
Thank you.
Please.
May it please the court, I am Robert Soriano Hewitt, staff attorney at the Legal Aid Society, attorneys for respondents Priscilla and Ochieze Okoronkwo. In this case, the lower court made a deliberate determination that a foreign LLC was indeed doing business in New York in violation of New York's LLC laws, not because they happened to file a case here or there to foreclose on a New Yorker's home. It's because their entire business purpose, their entire corporate identity was centered around.
Counsel,
Yes.
I understand that argument, but also, did she somehow unspool her previous substitution of the current plaintiff for the plaintiff that, for NC, whatever it was?
Yes, sure.
NS 194 LLC. In other words, did she somehow stay that ruling or undermine it in any way? In other words, you have a new substituted plaintiff.
as far
so why
as-
doesn't that solve the problem?
Yes, to the point of I think it's a rather absurd proposition that you could obtain greater rights or sanitize all pleading defects, standing defects, or capacity to sue by an assignment and substitution. In fact, this court addressed that in Caring People Management Services LLC versus Assisted Home Care. It essentially said you cannot obtain greater rights than the predecessor through a succession. So I don't think that, I think it's a legal fiction that you could be absolved by a mere assignment and substitution.
Counsel, the bottom line is, they're suing to get back their money. I'm talking about NS 194. Aside from the fact that you didn't preserve your right to argue standing, doesn't actually, I think it's April 8th, 2026 case from the Second Department in Star 201 kind of just do away with that argument of yours?
No, Your Honor. And first, I just want to address the the issue of lack of capacity was raised in the pro se answer form. They raised lack of standing. The case law is clear that those concepts, lack of standing and lack of capacity, are understood interchangeably. There was also a indication that the failure to state a cause of action was indicated in the pro se answer.
Counsel, are they interchangeable? I mean, is capacity to sue the same as standing?
They are not the same, but for the purposes of the answer, the case law is clear. If prejudice has not been indicated on the other part, the preference for the courts is to allow the inference to be drawn that the defense was raised so that the courts can make determinations on the merits.
Do you want to raise one more point, counsel? I'll give you a minute. I'm not
yes.
asking for it, but.
Yes, well, and I think it's really important that I address the second department case. The second department, I believe, got it wrong on the facts and the law. They misinterpret 803A1. The 803A1 says you can maintain any proceeding or any action in the singular. They extrapolate this to say because the plaintiff in that case happened to file one or two cases or several cases, they interpret the statute as being basically granting unfettered access to foreign LLCs to sue New Yorkers in New York courts. The second department was, I think, wrong on the facts because it was reductive to classify it as merely bringing cases. If you look in the record in this case, there is records of them sending, purchasing the mortgages, servicing the mortgages, sending debt collector correspondence to New Yorkers, and commencing actions. And
You make that point in your brief that the pervasiveness of their behavior in New York
Yes.
overcomes that portion of the statute.
Yes, well, but the totality of the evidence is multiplied by the fact that the court did and could take judicial notice of the 20 actions that were listed in the NYSIF printout. And when you extrapolate those actions, you have 20 instances of sending several notifications, buying several mortgages, servicing those mortgages on a systematic basis. The purpose of LLC law is not, it's not a foreign limited liability company protection act.
You definitely unpacked that argument in your brief, counsel. Thank you.
Okay, thank you.
Hello, Your Honors. I believe that my learned colleague here has misunderstood and misstated what New York LLC Law 803A1 actually says. What it says is, quote, here we go. A foreign limited liability company shall not be considered to be doing business in the state for the purposes of this chapter by maintaining or defending any action or proceeding, whether judicial, administrative, arbitrative, or otherwise, or affecting settlement thereof, or the settlement of claims or disputes. Far from being a singular instance, it is a blanket exemption, statutory, that says the state of New York, as a matter of public policy, wants foreign entities to litigate in our courts. The reason is simple. It's because we want foreign entities to bring their issues with New York residents here, where we have the best courts in the world. That's just my opinion, but it is what it is. It's been proven by my own practice, I think. In any event, the other problem with the capacity argument is that the allegations made by my learned colleague here just happen to not be correct. Record page 79, record page 92, those are the 30-day and 90-day notices which are issued by the servicer. We cannot conflate the acts of other parties, other entities, other business organizations with NS 194. This record is devoid of evidence that NS 194 was doing business in the state of New York, and my learned colleague only introduced evidence of the maintenance and defensive actions. That, under New York LLC Law 803A1, does not constitute doing business. It's very simple.
So I knew your argument is that there is capacity, but if there isn't capacity, is an assigner barred from being a substitute plaintiff to commencing an action?
And I think that you can look at the decision that we're appealing from actually indicates that it puts a conditional stay to allow proof of this compliance to occur. If this was such a jurisdictional defect, how could that be a valid decision? It would either kill the action or not. The whole purpose of the cure is the fact that there's a substitution mooting the very issue. And I think this is just a
Thank you, counsel.
Thank you, Your Honors.
Thank you both. Andrade v. 1203 East New York Avenue.
Yes, may it please the court, Michael Cassell for defendants appellants. As we set forth in our papers, this court should reverse the lower court's decision granting summary judgment to the plaintiff as to 241. What you have here is an unwitnessed accident. The plaintiff testified that the device that fell, which was a roustabout, was damaged in the accident, and as I said, it's unwitnessed. We submitted an affidavit of Mr. Neula, the foreman, who said after this alleged accident, the roustabout was continued to be used. It was not ruined in any way, shape, or form. And as we set forth, for multiple reasons, the decision should be reversed. At least, number one, we explain how there's been no testimony of the coworkers. Like I said, it's an unwitnessed accident. We argued below that this is a premature motion.
No, you were just saying you wanted to get more discovery from the plaintiff's coworkers. Is that what you just said?
Correct.
You didn't make that argument below, though.
Correct. That's true. We didn't make that
The
exact
argument you made below was that you needed to get discovery from your witnesses within your control.
That is
It's not a
correct.
powerful argument, let's face it.
Well-
So anyway, did you waive it by not raising it below, the one about seeking discovery from the plaintiff's coworkers?
I submit we didn't waive it, Your Honor, to the extent that, number one, we argued that it was premature in totality. We did focus on, defendants per se. And secondly, we did cite some cases that it's something that's already in the record. The facts are there and the argument is there. We also, argue specifically that the key to the plaintiff's testimony, because he cannot establish as a matter of law that something fell on him, is his claim that he was supposed to act as a counterweight. It's our position that that testimony is basically tailored to get the case within Runner and its progeny, and we submitted the affidavit of Mr. Neula, who basically affirmed that plaintiff was never, ever instructed to act as a counterweight on the roustabout. Yes.
So, counsel, isn't it uncontroverted that the roustabout tipped and eventually caused him to fall?
Well, I'm sorry. It's uncontroverted to the extent he's the sole witness and it's unwitnessed and there's no other testimony.
So, wait. Are you saying that it didn't fall over?
I'm saying that it's an unwitnessed accident for which...
No. I'm asking you. Are you saying that the roustabout, that this crane did not fall over then?
I mean, at this point, there's no... I acknowledge there's no testimony to rebut the plaintiff's testimony that the roustabout fell over.
And that's not a problem with respect to labor law liability under 241, right?
It's not generally, of course, an unwitnessed accident, but the plaintiff also said that the roustabout was damaged when it fell, which we have rebuttable testimony, and he also claimed that it fell because he was required to stand on the legs of the roustabout, which we have an affidavit also that rebuts that.
So irrespective of whether he was asked to stand on it or not, isn't the fact that the roustabout, which is a type of crane,
Correct, yes.
fell over, and there's nothing to rebut that, doesn't that automatically get you into the damages checkbox as opposed to the liability checkbox?
Well, I think here, Your Honor, his testimony that he was required to stand on the legs of the roustabout, which would get it within Runner, is something that's been rebutted by the record by the affidavit of his foreman, who said he was instructed not to stand on the legs of the roustabout.
I think you're arguing damages, aren't you?
No, because there's an issue would be sole proximate cause if he's standing on the legs and takes a foolhardy risk of standing on the legs of a device.
And that's the reason why I've asked you about the unrebutted allegation that the roustabout fell of its own right. If that is the case and that is unrebutted, then you go into the damages box.
I understand, Your Honor. We also did raise the premature argument on it. So, is there
Thank
any?
you, counsel. You have more time on rebuttal.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. With regard to the preservation issue, there is a preservation issue because they didn't raise the issue of the coworkers, but even if it's below, they just talked about the defendants not being available, even though they didn't pursue any discovery. But more importantly, there's nothing on this record that they'd be able to offer that would change the statutory violation. This roustabout flipped. It failed at its core purpose for keeping the column upright and it failed to secure the load. It flipped over and then it fell on the plaintiff. So
Let's assume we buy your argument. What's the problem with allowing the testimony of a new witness?
Well, because there's nothing that's going to change a statutory violation, meaning that the plaintiff's testimony is unrefuted, that this tipped and fell over, and the affidavit that they put in, they could have put in an affidavit in response to summary judgment. What they did was put in a feigned affidavit by Mario, which didn't defeat summary judgment and didn't raise an issue of fact with regard to recalcitrance of sole proximate cause. Contrary to my adversary, Mario did not say, do not stand on the legs of the roustabout. This is what he said at 719 of the record, paragraph 8. I never instructed Mr. Andrade or any other worker to stand. I never instructed them to stand on the legs of the roustabout. Mr. Andrade should not have been standing on the legs while performing his work. At best, that's a standing order that doesn't raise an issue of fact with regard to a recalcitrant worker. He never said, do not stand on the legs of the roustabout. But even if he did, at most it's comparative negligence because we have a statutory violation. We have a roustabout, a device that failed in its core purpose, could not maintain the load, the 18-foot, 1,000-pound iron column that it was supposed to keep upright and raise. So two things. One, we know under Blake and its progeny that the plaintiff can't be the sole proximate cause, but also cannot be the sole proximate cause, cannot be recalcitrant because he did not ignore an instruction. There is no instruction not to stand on the legs. In fact, plaintiff's testimony is that he was instructed to stand on the legs. So to answer your question, long-winded, even if the co-workers were subpoenaed, which they weren't, and came to testify, which they didn't, or submitted an affidavit, which they didn't, said, I was never told to stand on the legs, or that's still a standing order. That still doesn't change the fact that at most it's comparative negligence because you have a device that's insufficient in the hoisting operation of this huge, heavy iron column. So that is why they were, and if there was to be something to refute summary judgment, they had every opportunity. The plaintiff was deposed in January of 2024, I believe, and summary judgment was in July. They had 8 months. And in this court's order, this court's decision in Sangare, which is really relevant, it's at 212-83rd 547, but it's in my brief, actually made a point of recognizing that there was no evidence that any non-party discovery was sought in response to defendant's argument of prematurity, made a point of pointing that out and highlighting that the defendant did nothing to obtain any non-party discovery. So our position is that the trial court got it right and summary judgment should be affirmed. If you have no further questions, I'll rest in my brief. Thank you.
Thank you, Counsel.
Just quickly, I don't dispute that if the accident happened as Mr. Andrade testified, that is a violation. But what we do have here is no coworkers ever deposed. It's an unwitnessed accident. Mr. Andrade said two key things. Number one, that the roustabout was damaged, it fell over, couldn't have been used again. That's directly disputed by Mr. Naula. And also, secondly, that he was instructed specifically to act as the counterweight.
Have you looked at the photograph that's found at record 728? This is a tall roustabout. I mean, the vertical portion is quite long, but the lower part, it has three relatively thin legs that are on wheels. There's not even any chocks there. Don't you have problems here with respect to liability?
I mean, well, we do to the extent the court's already granted summary judgment, but I understand that. But Mr. Naula has disputed and said the roustabout could hold up to 1,500 pounds, and also in paragraph 7, he disputes that Mr. Andrade was ever instructed to stand on the legs. Any other questions? Thank you. Thank you.
Thank you, Counsel. Thank you both. CSN Realty Corp. v. Musf.
May it please the court, Christopher Rados, Ovid and Ovid LLP, on behalf of plaintiff appellant CSN. This is an appeal from the motion court's order dismissing our complaint against respondents. Respondents formed a deliberately
You
undercapitalized.
must have a big voice in there, because I can't hear you.
Is this better?
Thank you, counsel. Listen, so your client knew that the judgment debtor was a special purpose vehicle, right? Okay. Now, how then could it reasonably rely on Mr. Roy Musia, well, let's call him Roy, and Mr. Al-Kafadi's representations?
Well, there's a few reasons, Your Honor. There's no rule in New York that SPV status alone provides some type of blanket immunity for veil piercing. Respondents don't cite any authority for that proposition. In fact, as we cite in our papers, courts have held otherwise. So long as a plaintiff pleads veil piercing, special purpose status is irrelevant. In addition, going to that personal guarantee, our whole point is that our client was fraudulently induced to forego personal guarantees due to the misrepresentations by those two individuals, Roy and Al-Kafadi.
How about by the time they got to the Second Amendment, though, at that point, you kind of see that the judgment debtor was dragging its feet a little bit on the deal, and so then shouldn't they have had their antenna up, like, oh, okay, this is an entity with no assets, and so maybe we should start thinking about this?
No, Your Honor, I don't agree with that. We entered into this contract in good faith. We expected them to perform. They didn't. We later learned that these representations were fraudulent. That's the basis for the fraudulent inducement claim and the alter ego veil piercing claim based on the breach of contract. Going back to just the fraudulent inducement claim, it was error for the motion court to dismiss this claim based on the merger clause. This court has been clear in numerous decisions that a general merger clause, a boilerplate clause, like the clause in this contract, cannot bar a fraudulent inducement claim unless it expressly disclaims the particular misrepresentations at issue. If you look at this clause, it doesn't do that.
Does it matter that in the contract there is this warranty saying, yes, we have enough money to close? It's in the contract, so there's a warranty in there. So does that affect the statements that allegedly give rise to the fraudulent?
No, it doesn't, Your Honor. The warranty does not at all. Actually, there's on-point case law from this court on that. It's the Weil case, VXI as well, MBIA, all of which are cited in our papers. Those cases hold that a warranty is a statement of present fact, not a promise of future performance, so it doesn't bar a corresponding fraudulent inducement claim. So that warranty argument, there's no merit to that, Your Honor. Getting back to the merger clause, though, as I stated, there was...
So, counsel, isn't there not only a merger clause, there's also NAR that also expressly states that there's no reliance upon representations? How do you address that argument?
So the NAR argument, that's respondent's characterization. When you read this clause in conjunction with the controlling case law from the First Department, which we cite in our papers, Merrill Lynch, Liberty Bank, Healthwave, Ladzinski, this is not a no additional representations clause. It simply says neither party is relying upon any statement or representation not embodied in the contract. That's a boilerplate merger clause under that case law. And if you look at all the cases that respondents cite in their papers, every single one of those had a materially more specific merger clause. The language is different. So it either targeted the particular subject matter of the representations forming the basis of the fraud claim, or it expressly disclaimed inducement, which this clause does not do. The other cases they cite to try to prop up that argument, in addition, the courts don't actually analyze the specific language of the merger clause. They just explain that the merger clause somehow barred the claim without getting into specifics, so we really can't do any analogous comparison to our case here.
Was there an opportunity at any point in time to discern the actual financial, I'm going to call it integrity, of the defendants?
No, I don't
They
think
had a zero bank account, but they were going to buy something that was in the millions, right?
we didn't find that out until later, and again, we relied on their representations to us, and that was the basis for inducing us into the agreement. One, at the time of contracting, that they presently had sufficient capital to purchase the property, and then again, at the time of the Second Amendment, that they had the capital to pay the amounts due under the Second Amendment, as well as these additional closing fees.
Due diligence conducted by your clients?
At the motion, we're at the motion to dismiss stage. You know, our client entered into this deal in good faith to purchase the property.
Can you address plaintiff's argument that, defendant's argument that your clients could have asked for personal guarantees or to fund the escrow or some other means of protection?
Yeah, the whole point of the personal guarantee argument is we were induced not to ask for personal guarantees based on their representations that their entity had sufficient capital at that time, at the time of the representation, to purchase the property, and again at the time of the Second Amendment. That's why we forewent the personal guarantees, Your Honor.
Thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors. Joshua Siegel for respondents. May it please the court. Your Honor, there was no fraud here. Counsel obtained
How much was in the bank account?
Excuse me, Your Honor?
How much was in the bank account? Zero?
The bank account for the judgment debtor was used to pay all of the debtor's expenses in connection with the due diligence for this property, which required.
Was it being funded little bit by little bit?
It was not.
As in, we have to put up this kind of money, so we're going to put so much in. But in truth, there's nothing. It's a zero unless I deposit directly.
Well, Your Honors, the fact of the matter is that every single purpose vehicle of which plaintiff was well aware that this was one has to be infused with capital by its members.
Was there a zero bank account
At the
balance? Was there a zero?
Yes, there was. At the conclusion of the transaction, there was no money to pay for this property. Counsel, on behalf of his client, brought a case, breach of contract. That case was successful. A judgment was
And
rendered
there were
against the
lots of
non-party to this.
extensions of time afforded, right?
I'm sorry, Your Honor?
There were there were several extensions of time
Yes, Your
afforded
Honor.
in order to put that money in the account, but it never happened.
Well, in exchange for those extensions, the plaintiff here received $600,000 in the form of the down payment. It also kept the property in addition to pursuing its other claims. So counsel is.
In addition, it kept its own property.
It did. It did not.
But the
But it
property
couldn't
was
do
off the
anything.
mountain, right? Off the market, not mountain, market.
And in exchange for that extension, there was a $600,000 deposit that was released to plaintiff. Your Honors, the fact of the matter is that the plaintiff received discovery in the form of all of the bankrupt records before it commenced this action. It was unable to identify any looting of this company, any misappropriation of funds. There was no allegation, there is no allegation that any of the monies for this company were used to pay personal expenses or any of the defendant respondents' expenses in connection with this. The fact of the matter is that the transaction did not conclude, and now plaintiff is unhappy with the fact that it contracted with a single-purpose entity. It cannot now gain greater rights than it never had in the first place without alleging a fraud. And so what does it allege? It alleges that some of the defendants assured them prior to signing, which, by the way, there's nothing in the record about this.
Counsel, can we just
Yes, Your Honor.
pivot to the fraudulent inducement as to the individual defendants, Roy and Al-Kafadi?
Yes, Your Honor. So the merger clause, merger clauses, there are two here. There was a merger clause in the original contract and then a no additional representation clause in the rider. The members of the debtor are covered by that. The case law cited by plaintiff to suggest that members of an LLC that sign an agreement are not covered by a merger clause concern third parties to that agreement. They concern an attorney, I think was one case. Another case was a real estate broker. These are not the members.
Are there any cases where someone that was a member of the LLC would speak individually rather as part of the LLC, where this court has sustained a fraudulent inducement on an individual basis?
Yes, Your Honor. That is, bear with me, Your Honor, there's about 1,000 cases in
It's a hard question.
in this briefing.
I don't remember any cases where individual was.
I'm sorry, Your Honor, I misspoke. The only cases that were addressed by plaintiff concerned non-members. There is no case cited by the parties with respect to this issue.
I could not find one.
Neither could we,
Was
Your Honor.
Roy a non-member? Because he invested in the judgment debtor through EMR, correct? So he himself is not a member of the judgment debtor. Go ahead.
No, I believe Roy is a member and has an interest in another member. There are 4 members of the judgment debtor here. I believe they are.
Right, well, Roy and Leo are owned through other entities, I gather, correct?
Correct. The fact of the matter is, plaintiff sued not only the members of the judgment debtor, but anybody else they could find, members of members. So in theory, plaintiff would have to pierce the corporate veil twice. I'd like to end where I began
Where
here, Your Honors.
corporate-
There was no...
Question.
Yes, Your Honor, I'm
Were
sorry.
corporate formalities observed, such as holding meetings or keeping proper company records?
There were no meetings, there were records kept, obviously, and all of the transactions were memorialized in the bank records, in the tax returns. This was not an entity that did nothing, contracted, took no action, and never paid. The facts of this case are that the judgment debtor performed its due diligence with HUD in order to get this property permitted, approved for the purpose that it sought. When that purpose became impossible, they could not close. Counsel sued. They kept their $600,000. But the mere fact that they were, I'm sorry, I'm running late. I'm just trying to answer your question. The mere fact that they didn't hold meetings doesn't render their corporation a fiction. Thank you, Your Honors.
Counsel.
Just a few points to address quickly in rebuttal, Your Honor. You had asked counsel as to whether there was a zero balance in the bank account, and counsel responded at the conclusion of the transaction. That's inaccurate. The record reflects, and the discovery, the limited post-judgment discovery we got in the underlying case indicates it was at the time of the misrepresentations. So there was a zero balance at the time that the representation was made, that the entity had sufficient capital to purchase the property, and again, at the time of the Second Amendment. That's the entire basis for the fraud claim and why we brought this action.
Does the record show that there was intermingling of funds?
Yes, it does, Your Honor. There was commingling of funds because the $600,000 down payment was paid entirely from respondent's personal accounts. It didn't even come from judgment debtor in the first place.
Is that the same as intermingling, though? It sounded like the members of the judgment debtor would occasionally pay bills on behalf of the judgment debtor, but was there any bank account where the funds were intermixed?
I can give one. There is one example we did get of intermingling. The entity Street Denim, one of the respondents, did put funds into judgment debtor's account and then paid an obligation through that. So the funds were mixed in that instance. But again, this is just based on limited post-judgment discovery. I did want to address just very quickly the veil piercing aspect.
We've kind of been talking about that already.
Well, the basis for the motion court's ruling. I just wanted to make clear the court erroneously dismissed that claim. The analysis was flawed. The court focused improperly on a single factor, even though this court has repeatedly held it's a multitude of factors, none of which is dispositive. The motion.
You also addressed the fraudulent inducement as to individuals, because you cited a case, Remediation versus Noto, which was an attorney, not a member of the entity. So is there any cases, or how do you come to the fact that you're calling these individuals as non-parties, even though they were members of the LLC?
So the merger clause is limited to statements by the parties. They don't cite any authority indicating that every member of an LLC, however it plays out, is entitled to protections of every contract they sign. We distinguished all their cases. None of them have to do with fraudulent inducement claims, merger clauses. The only case they cited that extended protection to an agent, not even a member of an LLC, was Little Nest. The other cases are distinguishable. We also cited authority that non-signatories are not bound by contractual provisions, even where they're agents. But there is no case, I didn't find one either, extending it to LLC members, Your Honor.
Thank you, counsel. Thank you
Thank
both.
you.
Next case up is Mcom Estates, VCMB Export Infrastructure. Please.
Good afternoon. May it please the court, I'm Richard Haddad for the plaintiff's appellants. This case presents the question of whether a litigant obtains immunity from malicious prosecution liability by fraudulently obtaining a preliminary injunction. And the answer
Counsel,
has to be
would
no.
you concede that Justice Ostrager's decision granting the preliminary injunction, denying the motion to dismiss, that at least creates a presumption of probable cause to bring the prior action?
Yes, it does create a presumption, but that presumption is defined by the Court of Appeals in the cases that we've cited. In the Wolf case, affirming the appellate division, says that that presumption is rebuttable. And it's rebuttable.
In rare cases, I
It
forget.
is a rare case. No, yes, it is a rare case, and this, Your Honor, is that very rare case, and here's why. Because that preliminary injunction was obtained through fraud, perjury, and the withholding of evidence. As was explained below, 109 separate misrepresentations were made to induce Justice Ostrager to issue that injunction. And when you have that level of misstatements, when you have them denying the existence of a document that they had in their own files, both the lawyers and the client, and they had that document disclosing the existence of the participation agreement, disclosing how the $275 million was going to be used, and they come to court and say, we have no idea. If we knew that, we wouldn't have done this.
Wasn't there a re-argument motion, and Justice Ostrager reaffirmed his preliminary injunction?
There was, and why that is important is twofold. Number one, the re-argument hearing, because this document was withheld for a long period of time, the re-argument hearing came after the new Los Angeles transfer tax law went into effect. And so by the time of the rehearing, we'd already lost $100 million in value by virtue of this transfer tax law that came into effect. And that was the reason why they ran to court. They ran to court to try to get the injunction because they knew we would face pressure. They knew that they were a junior creditor. They would face pressure. We would face pressure if we couldn't foreclose our equity interests before that transfer tax
Counsel,
changed.
I
The
thought,
second point, I have one more point to that, but I'll answer your question.
I thought that it was the term sheet that inferred that there was a participation agreement. Are you arguing that they had in their possession that participation agreement?
No, I'm
I
not
thought you
inferring-
said that earlier.
I'm sorry, I'm saying they had the document in their possession that said.
The document is what? Is
The
the,
document was the term sheet.
okay, thank you for,
A 9-page detailed term sheet that said there'll be a participation agreement, there'll be transfer restrictions, and here's how the $275 million is going to be used. That's what they had. And in fact, that was the document that this court found to be critical in reversing and vacating the orders below and in finding and throwing out the fraudulent concealment claim, the very basis for that injunction. But to get back to the question, in addition to the Justice Ostrager's rehearing argument being after the damage had already occurred, what happened as well is by that point, he had already in his head and in his deeds and in his words heard of an evil scheme. That was his words, not my words, that this was an evil scheme, when really what it was enforcing of contractual remedies, as this court recognized. And he had already found that.
Justice Ostrager considered the term sheet in his motion to re-argue.
He did, he said he considered it, that's correct. And he said he considered it and he upheld his original decision. But what happens here, Your Honor, and what we submit makes this particularly egregious, is that they went into court and they doubled down on additional false statements as laid out in our pleadings. And when they have that additional level of misstatements, at a minimum, they should be, the presumption is rebutted. We should be entitled, they should be required to put in their answer, and a motion to dismiss should not be granted. Just as in the cases that we've cited in our papers, including the First Merchants case. And so we would ask that the case proceed to put in an answer and the order be reversed.
You have time in rebuttal as well, Counsel. Thank you.
Good afternoon. I'm Peter Shapiro, the lead attorney of record. I'm introducing my colleague, Jonathan Preziosi, who's a member of the New Jersey Bar, who's been admitted pro hoc vice, to argue.
Thank you, Counsel. Please.
Thank you very much, and if it would please the court, I want to use my time to demonstrate how the presumption of probable cause was created and how the complaint for malicious prosecution fails to state facts sufficient to overcome or rebut the prima facie showing of probable cause. The probable cause that we will establish here, and I want to focus the court not on the original grant of preliminary injunctive relief, but on the court's subsequent denial of the motion to vacate the preliminary injunction. That gave rise to a presumption of probable cause. The complaint in this case sets forth 0 facts to overcome the presumption of probable cause created by Justice Ostricher's
But, you know, you've
second
got that,
decision.
you've got your opponent saying the participation agreement is referred to in the term sheet as having transfer restrictions.
That's
Doesn't
right.
that put you guys on notice that you got to look into that?
Right, and that's why this court ultimately reversed the Justice Ostricher's decision and dismissed the complaint. But the question here is probable cause. And if I could return to the second order by Justice Ostricher, which denied the motion to vacate the preliminary injunction. The defendants, now the plaintiffs, put in front of the court the draft term sheet and argued that the draft term sheet, which does make a reference to a potential future participation agreement, argued that that term sheet and its existence gutted the claim for fraudulent non-disclosure, fraudulent concealment, and further argued that both the representatives of the respondents, CMB, and my firm engaged in misconduct in not disclosing the existence of the term sheet earlier. Now, of course, the term sheet was produced by my clients in discovery. It was not intentionally withheld. Regardless, Justice Ostricher took into account the contents of the draft term sheet, heard all of the arguments about fraudulent concealment of evidence, false testimony, misleading the court, and entered a cogent and well-reasoned opinion that the one-line reference to a potential participation agreement with a lender who had not yet even been selected to be a lender as part of this project would be insufficient to put my clients and Louis Brisbois on notice that not just that there would be a participation agreement, but that this participation agreement would specifically name my client as a junior mezzanine lender a prohibited
The
transfer.
ICA has a section 4C, right, which allows your client to right to purchase interest in the senior mezzanine, right?
That's right.
And so and I gather that was an important right to your client. So why weren't they put on notice by the the participation agreement that they should be looking into that?
I appreciate Your Honor's knowledge of the record. The court will recall there is also a Fourth Amendment to Intercreditor Agreement. That was the document that my client executed and gave its consent to Reuben Brothers becoming a participant, or I should say, a project lender. That document included a schedule of all of the senior mezzanine loan documents. The participation agreement was omitted from that. So I would just posit, I don't want to re-argue the court's dismissal of the fraudulent concealment claim. I want to focus just on
Probable cause.
the presumption of probable cause and the fact that the complaint does not set forth any facts to overcome that presumption. What does the complaint allege? And this is all at paragraphs 93 through 103 of the complaint. It alleges that CMD didn't disclose the draft term sheet. Well, that's impossible to overcome the presumption of probable cause because Justice Ostricher had it in front of him and fully considered it when denying the motion to vacate the preliminary injunction. The complaint also alleges falsely that the Appellate Division found CMB's claims to be frivolous.
You don't have to belabor that. We know what we said, counsel.
I know you, Your Honor, knows that. And finally, the complaint alleges that the Appellate Division reversed. But of course, the court is fully aware that the mere reversal by the Appellate Division does not negate a
There is
presumption.
case law on that, and you cite it. Thank you.
Thank you, Your Honor.
Please.
Thank you, Your Honor. The issue with respect to the presumption, we come back to it is rebuttable. And when we say it's rebuttable, what is it rebutted by? Well, it's rebutted by a demonstration or a pleading that they made misrepresentations or withheld evidence in connection with obtaining the order upon which the damages were based. And that order, as I indicated, was the initial preliminary injunction, because that came, then the tax law came into effect, then we had the rehearing. And they stated in their presentation to get that initial injunction time after time after time, and we've cited it throughout the pleadings at page 509, 529, 543, 544, time and again, that they said, we knew nothing about this, and that was in fact wrong. They said, we didn't know how the money was going to be spent. That was in fact wrong. They said that we didn't know there was going to be transfer restrictions. That is in fact wrong. They said we were charging a usurious interest, 30%. Oh, that's in fact wrong, because a participation doesn't change the interest rate. It just reallocates it among the interior participants. It doesn't actually change the actual interest rate. So they made misrepresentation after misrepresentation. And that is precisely how you rebut that presumption. We know the reversal by this court doesn't automatically open the door to a claim, because if that were the case, you'd have a claim multiple times a day. That's not the case. I think this is my first time in 38 years bringing this claim, because I looked at this and what I've seen is this case says 109 misrepresentations, and they used it for this nefarious purpose of getting an injunction at a time when they knew this law was going into effect, and that was going to be the damage, and they wanted to stop it, because if we foreclosed our equity, we could flip that on the equity, which is what my clients had. We could flip and sell that property before that new tax law goes into effect. We were unable to do that, and that caused damages. They knew that's what was going to happen. That's why they fought so desperately to get that injunction. Your Honor, affirmance here would create the perverse rule that the more successful a litigant is in deceiving a court, the more immunity they receive from the consequences of that deception. And we submit that would be an unjust result, and they should be required to plead and prove their defenses, because that's how that presumption can be rebutted and addressed.
Thank you, counsel. Thank you both. Blumenfeld v. Smith.
Please the court, my name is Harry Shapiro, and I represent the defendant appellants. In the case at bar, there are 42 causes of action. There are 14 causes of action for conversion, 14 causes of action for breach of fiduciary duty. If you look at the 14 fiduciary duty complaints, there's almost absolutely no specificity at all that's required by CPLR 3016B. They make claims of excessive management fees, but they don't claim when they were taken, how they were taken, how much they took. They make claims of excessive interest rates.
Counsel, what's wrong with paragraph 72?
Paragraph 72 is the only specific in the conversion causes of action. But if you look at the documentary evidence, we followed each of those allegations and showed that they were all accounted for. The court below, in fact, asked counsel, can we get rid of those causes of action?
Counsel, isn't this a 3211 motion, an affidavit to be insufficient to rebut the four corners of the complaint, which wherein there are allegations in paragraph 72?
Yeah, we had documentary evidence, which was argued, and documentary evidence showed where that money, the allegations in the complaint is that money was taken but not returned. So we showed specifically with documents from the bank and checking accounts that the money was returned to the rightful owner.
But how does that address the intention behind the original transfers?
When you say the
intention, you can say it was returned, but aren't they entitled to look at what was the reasoning for those transfers?
The causes of action are for conversion. They're claiming that they converted these funds. They say in the causes of action that the money wasn't returned. Now, these transactions took place in 2020, 2021. This action wasn't started until 2024. So the money were returned as soon as management found out that there was a problem, they were returned. For example, there are two payments, they claim payable, there were two checks payable to 112 Madison. They were payable to 112 Madison, but they happened to have been deposited into the 405 partnership or limited liability company. They were returned. The claim and we documented how they were returned, when they were returned, and they were never supposed
I think one thing that Justice Kelly O'Neill's question raises for me anyway is, how do you know it was just a mistake? You have to rely on the affirmation, and the affirmation is not documentary evidence for a 3211 motion. So all you got is a bank record saying that these things happened, they were transferred back. You guys have your argument about that. But what was the intent in the initial transfer of money before it was transferred back? So how can you unpack that in a 3211 motion when it's really a summary judgment issue at best?
Well, in the 3211, in a cause of action for conversion, you still have to have intent. They never alleged that this was done with intent.
The complaint also talks about these loan, you read the complaint obviously closely, more closely than I have, that they allege that the defendants took monies from the various nominal defendants and then loaned the money back to them and made a little profit there. What was that about?
There was no such thing. That's not what occurred. I understand it's a 32.
There's a pleading motion, though. That's what they said
I
happened.
understand it's a 3211 motion. But what occurred here is that loans were allowed to be made under the operating agreements.
If they were in the interest of the nominal defendants, and that's their argument, that they were not in the interest of the nominal defendants, rather the defendants were making money off of these loans. That's what they're alleging. How do we get around that?
Let's go for a second to the breach of fiduciary duties. In the breach of fiduciary duties, the 14 causes of action, they don't allege a single fact, a date, an amount. For example, when it comes to the excessive fees, how much were the excessive fees? Who were they given to? How much was taken?
One thing they say is that the use of SAMCO sort of treated the 14 nominal defendants as a conglomerate. That's a word that they use in their brief, and that would be improper because each of them had their own operating agreement that specified they had to have their own accounts kept separate, like escrow accounts. So that potentially, could lead to a viable breach of fiduciary duty.
This court denied our request for a bill of particulars in a prior appeal.
We did that?
Yes, you did that.
Okay.
There are 65 pages here. There are 355 allegations. There are 42 causes of action. You denied it. You made a comment. I was sitting here while it was argued that, but you said 500 demands for a bill of particulars. If you break that down to each cause of action or the 42 causes of action, it's like 25 demands per cause of action. Okay, now I'm here and I go, how am I supposed to defend my client? CPLR says in a breach of fiduciary duty, you have to have specificity. I don't have any specificity with respect to any of the 14 causes of action for fiduciary duty. Then they incorporate each one of them,
Right, you make that argument in your brief that the adult children of the Smiths were not parsed out at all as to what they did with respect to these transactions. But we'll talk about that more on rebuttal, counsel. Thank you.
May it please the court, my name is Fred Weinstein. I represent the respondents. As this court undoubtedly knows, a motion such as the one that was made below pursuant to CPLR 3211.
Let's pick up that thread, though, about particularity with respect to the breach of fiduciary duty. How do you break out what the adult children of the two Smiths did? Is it broken out in the complaint?
Well, we note correctly that all of them were managing these entities. They were managing members. The children were co-managing members in several instances. Mr. Smith's affirmation indicates that the children were involved in managing these entities And all of them were also shareholders of Samco and were participating in the management activities of Samco in managing the money. And as you observed, Samco, and was noted in our complaint in the briefing, the operating agreement, which is one of the few pieces of documentary evidence they provide, made very clear that the entities, the purpose of these entities was to promote the interests of the entity in the property that it owned.
Is your client trying to pierce the corporate veil?
Not at all. Not at all. We're holding them responsible for their own bad acts. Their acts as managers in taking money that should have been kept segregated in a separate account in the names of these entities and used only to further the purpose of those entities. Instead, admittedly, the money is swept away from these entities, placed and commingled in the Samco account where they all have an equity stake, and then used to further their self-interest by lending this money back to these entities, all of which they concede were profitable. And had they not taken the money, they say it was a loan, but there's not one piece of documentary evidence showing that it was a loan. But even if we accept that it was a loan, there is absolutely no right on their part to commingle the money and operate this mini bank and take profits to which they weren't entitled. These entities clearly were entitled to use their money in furtherance of the purpose
And
for
are
which
you,
they were.
are you addressing the rental income
I'm addressing the rental income, which was,
diverted?
I'm sorry, Your Honor.
Diverted?
Diverted, yes. Taken from these entities and admittedly placed in the Samco special account. That violated the operating agreement. And I think it's noteworthy that in their briefing, they quote the operating agreement, but they very obviously left out the language in 6.05, which indicated the monies had to be segregated and the managing member could not transfer these assets for any other purpose but to further the interests of the entity. This was something that they did admittedly together and improperly. And not only did the money get improperly diverted, they then used this money not only collecting interest to which they weren't entitled. We noted in this complaint in great detail, they took brokerage commissions to which they weren't entitled. They used money to pay affiliated entities to do work. They also charged under market rents at one of the building that Samco happened to be a tenant at. My colleague here, he's also a tenant at the same building. That's an allegation in this complaint. So there's no shortage of indications that what they did was self-dealing. And as to the breach of fiduciary duty.
Counsel, you keep on saying they, and my colleague talked about group pleading. What did Joshua, Rebecca, Adam, or Zachary do that's alleged in the complaint? In order, as counsel just alluded to, how does defendant defend themselves if you don't specify, at least in a fraud claim or breach of fiduciary duty claim, the actual allegation as to each of the individual defendants?
Well, the facts, as you know, Your Honor, have to be sufficient to allow a reasonable inference of the conduct. Here, we alleged, and they don't dispute this, that—
Can you answer me, do you have Joshua, Rebecca, Adam, Zach, any individual allegations as to those defendants?
we note that they were all members of the Smith family, and all of the members of the Smith family were shareholders of Samco, and all of them were involved in this diversion of funds. And so the fact that they were acting in concert, that's permissible. The case law is very clear. If they're all engaged in the same improper acts, they're all properly named together. And so I respectfully submit we've adequately pled that. And I will also note that there was a suggestion below, and I'll be very brief, that there was a statute of limitations issue. When asked by Justice Crane, he acknowledged the limitation period is 6 years, and this court has held numerous times that derivative claims are equitable claims.
Even if we don't touch that, I think that might be revisited at the trial level. Thank you, counsel.
Thank you.
Jeffrey Smith, in his affidavit, said that my children helped manage the buildings. From that, the court below extrapolated that children are all operating managers or managing members. everybody who is employed in a company helps manage a building. A super helps manage a building.
Sole managing members, definitely. You make this point. We're just Michael and Jeffrey.
That's correct. So how all the children became elevated to be managing members is just unthinkable in terms of this case. Just because the father said, you know, they helped me manage the building. They're employees. They got paid as employees. They were shareholders, yes, but that doesn't elevate them to operating managers or managing members. They say, counsel said that the money was commingled. Once the money is commingled, you can't have a cause of action for conversion. This court has said that. It's in my brief, time and time again.
Yeah, that's an interesting point that you make in your brief, but it's a difficult question because it's sort of a matter of degree, isn't it? How much has been commingled in a given account?
We don't know because they don't make the specific allegations, and they include that in their fiduciary claims also. So in all fiduciary claims, they're just general statements. And he said excessive management fees, excessive interest rates, affiliated contractors. We don't know who the affiliated contractors were, when they were paid, when they were hired, how much they were paid, how much was diverted. Rights of first refusal is also in the brokerage commissions. We have no dates for brokerage commissions, when they were paid, how they were paid, how much they were paid, who the brokers were. I don't have those specifics either.
I mean, I can hear your opponent saying, well, we need discovery on all those questions. He's not saying it, but I'm just saying, you can imagine he would say that. And you would say it too.
I would say that the CPLR 3016B mandates specificity. They admitted that they received information, and the complaint says that they relied on information that they received for these allegations. If they had the information, why didn't they provide it?
Thank you, counsel. Thank you both. Perez v. Kew Gardens.
May it please the court, Jessica Smith for NYC Elegant. Just very briefly, the testimony of the only sworn witnesses in this case do not connect NYC in an agent or general contractor role at this project. The work permit alone is insufficient, as this court and other courts have held, and the stricken unverified answer of a co-defendant has no evidentiary value whatsoever, and it's not even our admission. How could it be used against NYC Elegant?
Can you address the permit that was issued to Elegant?
Sure. So they're essentially the witness Carlos Bajarona testified in this case that the permit was in fact pulled. It was listing general contractor, NYC Elegant as general contractor. However, he explained that after they pulled the permit, the owner, Kew Gardens Dev Corp, never actually then contacted them and hired them to perform the work. So they never actually worked on the project at any point in time. They didn't hire any contractors to work on the project at any point in time.
You rely on Mr. Barajona's testimony, of course, for that purpose, right?
That's absolutely correct. So the reason why
they say they're not here, but did you have to rely instead on Agudelo's? Did you need Agudelo as the head of the company?
No, we didn't. And there's nothing that says that you need the owner or principal of a company to support a summary judgment.
Also, there were like 5. How many employees were there?
There's about 5 employees. And Bajarona testified that, him and Agudelo worked as a team. He was a project manager. He was aware of every single project that they had at the time, and he was working there on the date of the accident.
Does the fact that the permit found at record 480 indicates that NYC Elegant Improvements is a general contractor? Is that something that we need to be concerned with?
No, because as the Court of Appeals said in Walls, a label is not sufficient to establish that you're a general contractor, and it really has to go to whether you're the eyes and ears of the owner, whether you have the authority to control safety on the site, whether you're coordinating all of that. So that it has to actually be a substantive showing. So the mere fact that it lists general contractor is insufficient. And I would point to your case in Kylan.
There was never a contract. They never visited the site. They never supervised.
Correct, and they were never paid a deposit, which Bajarona testified to. So,
thank you, counsel.
Thank you.
OFC Brook Holdings v. Sprung. Please.
Good afternoon. My name is Mazen Sabeti. I represent the appellant OCF Brook Holdings. This is an action to enforce a guarantee on a roughly $14 million loan on a property in Minnesota. It was signed by three guarantors, two of whom are highly sophisticated New Jerseyans who had the large enough balance sheet to be able to guarantee that. They were highly sophisticated, represented by
So Judge Patel found that the res judicata applied. You don't think so, obviously.
True.
So the guarantees, aren't they very broad, and they allow someone to bring a lawsuit either against the borrower, but also against at some other time, at some other place?
Absolutely. And the guarantees have at least 5 or 6 provisions that address that. The 2 key provisions that are standalone sentences, that are standalone covenants. One is the middle sentence of Section 5A, which says the lender may enforce the guarantee in an independent proceeding of any loan foreclosure or of any deficiency action, either before or after an action against the property or an action against the borrower.
But were they addressed in the Minnesota court? Those sections?
No, those sections are in the guarantee. The guarantee didn't come up in the Minnesota court. It's not part of the foreclosure.
There's
I
also,
would
of course,
point
the
out.
previous motion to dismiss in this case where the borrower was dismissed from the case, and it seemed like Judge Patel was relying on that finding. Right?
Yes, Your
On the
Honor,
previous
and
motion to dismiss.
I think it seemed like it, but I think the fact that the borrower, who is a signatory to the loan agreement and is not a signatory to the guarantee, it's a whole different set of reps. It's a whole different set of covenants. The borrower in the loan agreement, Section 8.2, did waive any reliance on a one-action rule, but the fact that Judge Patel found res judicata applied in the motion to dismiss level had nothing to do with the fact that the guarantee itself allows the guarantors to be sued separately from the borrower. So, we didn't necessarily pursue the borrower, an appeal of the original order, because the borrower has no assets and we're not really here to waste people's time and money. It's not because we agreed with her ruling. But here the guarantee very specifically says the guarantors can be sued in New York. They can be sued before or after a foreclosure. They can be sued in an independent action. They can be sued irrespective of if there is a judgment. They can be sued irrespective of if there's a circumstance that constitutes a defense or a discharge of a guarantor. And it goes on and on. Section 5K specifically says that the obligations of the guarantors survives a foreclosure and survives the exercise of any or all remedies that the lender has under any of the other loan documents.
But the guarantee would, you can sue under the guarantee only if certain provisions were triggered, correct?
No, I don't agree with that.
Section 9?
Yeah, I don't agree with that. They can sue under the guarantee without any preconditions. What the confusion that the defendants and now the respondents tried to create is that this is somehow a springing guarantee. But the guarantee is always enforceable to the extent the borrower has any liability. The borrower's liability in Section 9.4 A, B, and C is variant. It depends on what bad acts they do, gives rise to different liabilities. In order to consider this a conditional or a springing guarantee, you'd have to find a circumstance where the borrower is liable, but the guarantor isn't until some condition precedent is triggered. You don't have that here. As soon as the borrower is liable under any provision of Section 9.4 in the loan agreement, the guarantors were unconditionally liable for that liability. And that much is pretty much undisputed as far as I can see it. They try to convert that into a springing guarantee or a bad boy clause, but it really doesn't work because they're liable for everything the borrower is liable insofar coextensively and coterminously with the borrower. It's lockstep. The point, I'd move on to say that, the guarantee, I think, is enough for a reversal. I would also point out, though, that they've completely abandoned their arguments on our cross motion for summary judgment. It's partial summary judgment. Our argument was essentially the reasons why they don't get res judicata is the reason why it should actually be dismissed and doesn't need to go to trial. And then we argued why all their other affirmative defenses really had no merit. I won't belabor those here today. They've abandoned all of those arguments. So I think as it stands, if we win on res judicata, then all their affirmative defenses go away, and the only thing that goes to trial really is the core liability issue. Justice Moulton looks like he's about to ask me a question, so before I start.
I'm a little perplexed by that because the Supreme Court didn't reach these issues. I feel like we're kind of flying blind a little bit on them. So what about a remand for her to consider your motion more completely?
I mean, certainly I would think that's within your purview, but I would just emphasize and point out that they've abandoned them completely. They didn't really argue them below. And if you look at the rationale behind why those defenses don't make any sense, they fall into three buckets. Most of them aren't affirmative defenses. They just deny elements of our causes of action. That's not an affirmative defense. We asked for evidence to support their affirmative defenses. They produced none below. So there wouldn't be anything to discuss about those. And thirdly, for most of them, their affirmative defenses dovetail with the res judicata issue, which is already being handled. So I think it would be most efficient for you guys to simply push, grant our motion. And I'll.
Please.
So were they not addressed because after Judge Patel said it's barred by res judicata, everybody just let everything else go?
No, they addressed them. They addressed them below. They didn't address them here in their response to our opening brief. Their responsive brief speaks no words on defending our summary judgment issues on their affirmative defenses.
Thank you.
Did I answer your question? Okay.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Gabriel Rosenberg on behalf of the defendant respondents Benjamin Schlossberg and Bernard Bertram from the law firm of Jacobowitz, Newman, and Torski. Just right off the bat, this is absolutely a springing guarantee. If you look at the language of the guarantee of recourse obligations, it doesn't say it's an absolute guarantee. It's only a guarantee of the recourse obligations. What are those definitions? Look right into the guarantee. The term is, the only thing that they are liable upon is on the guaranteed obligations, which, and I'm going to quote now, means the prompt payment when due, whether as stated maturity by acceleration or otherwise, of all obligations and liabilities of the borrower of which the borrower it shall become personally liable pursuant to the loan agreement and other loan documents as to the extent provided in 9.4 of the loan agreement.
Right, but counsel, doesn't the complaint contain enough allegations of bad behavior by your clients to satisfy that, or at least get past?
No, it doesn't. First of all, I represent the guarantors, so and the liability only springs from the borrower's actions.
Mm-hmm.
And this case was already litigated in Minnesota to the full extent where they got what they asked for, which was a judgment of foreclosure and sale. So that they had the opportunity to bring all these claims. All these claims were all known right before they brought their foreclosure action. This is not anything new, and they chose not to bring it.
Counsel,
yes.
The guarantee, as well as Minnesota law, does not provide for a single action.
Yes.
Why wouldn't that be why would be res judicata if single action rule is suspended in Minnesota and the guarantee itself provides for recourse in any event?
Yes, because in order to get to that recourse, they had to find that the borrower violated 9.4.
So that's a different issue. I'm talking about res judicata. It wouldn't be res judicata. You may have an argument on 9.4, but at the very least, we would get to the substance.
Yes, but in order to that, as in the first motion to dismiss, the borrower was already dismissed based upon res judicata as well, meaning that the court found, and this court should find as well, is that the 9.4 couldn't be triggered because they had an opportunity to bring that up in the Minnesota action. And the derivative liability of the guarantors only come into play if the borrower is found to have violated 9.4. Is there any other questions that, before I give it to my colleague?
Apparently not, counsel. Thank you.
Okay, thank you.
Good afternoon, Mayor Silber for Respondent Sprung. Judge Hagler, I'd like to address your Honor's statement. The record, the briefs have no direct law from Minnesota that says it can't be a single action in Minnesota. There are multiple cases that I've cited that says that where holdings were found or were made by the Minnesota courts that said we have a judgment of a foreclosure and an order of foreclosure and an auction, and then thereafter you can go collect on a guarantee. You can find a deficiency judgment in Minnesota, and then either it's part of that case, there are cases cited where those two actions were combined, or it's a question of order. It's a question of a separate action on a guarantee, but it's not a situation where Minnesota law forbids that kind of approach.
So they're not like New York, right?
I'm not sure I
New
understand.
York
New York, as I understand,
New York has a one-action rule.
Oh, as far as yes, that's correct. In New York, a guarantor needs to be brought into the foreclosure action itself. And that's a critical issue here because every item that they're raising here in New York was known to them in Minnesota and was specifically ignored in Minnesota. They didn't do all they could have in Minnesota, and Claystone Court of Appeals is very clear that that's not going to fly. You can't do part of a case somewhere else and then come here and try to get the balance of it when you had the opportunity to do it.
Does the one act? Yeah, we say the same thing.
Yeah.
Does the one action rule apply when the property is in a different state?
But this is not a foreclosure case. The one action rule, I don't know how it would apply in that light. There's no foreclosure here. This is a post foreclosure case based on guarantee, based on deficiency judgment that they never got in Minnesota. It's almost like putting,
so when there's property in a different state, isn't the one action rule inapplicable? Isn't it possible for there to be one portion of the action adjudicated, one part of the claims adjudicated in Minnesota and then another part here?
I don't know.
I'm asking you.
I don't know. I'm just not sure, though, how that's relevant to the res judicata issue, because that issue that they're trying to seek relief of here could have been addressed in Minnesota.
But
And
that
they don't say
doesn't
that it
bar
couldn't have been.
It doesn't bar them from bringing it here. The fact that they could have brought it in Minnesota doesn't bar it from bringing it here. And the guarantee is so broad that it even provides that they can bring the enforcement after the foreclosure.
So I'll address the guarantee language. So the question is not about an order. The question is not about first foreclosure and then action on the guarantee. They can always do that, but that's not the point. Res judicata says that if you have a case somewhere in Minnesota and all of the relief is available to you, sophisticated investors, they drafted the loan documents, all of the defaults that they're claiming of are all addressed and could have been addressed, known to them in Minnesota, and they specifically didn't get a deficiency judgment. They didn't get a final judgment. So now they're taking those open issues and trying to plug it into New York, and that's exactly what res judicata stops. Thank you.
Thank you, counsel.
My friend opened by reading the language of Section 2A from the guarantee and made the point that I opened with, which is that the guarantee guarantees the debts and obligations of the borrower. There is no condition before the guarantor's guarantee clips in once the borrower has liability under the loan agreement, which is exactly the point I opened, which is why it's not a springing guarantee. What he wants to argue is that, well, then the borrower then needs to have been found liable in Minnesota. It was. For all the other stuff that we're saying is liable, the other parts of 9.4b and 9.4c, 2 points on that. One, the borrower itself waived the one action rule in Section 8.2 of the loan agreement, so it could have easily been brought in. But the guarantee also says we don't have to bring in the borrower to litigate the borrower's liability as it pertains to the guarantee. That's what's in Section 5A. Second point I would make is on the idea of what we're really dealing with. The one argument they didn't address really in their responsive briefing and that we haven't heard of yet that I meant to bring up on my opening is we have a lot of liability that couldn't have been litigated in Minnesota because it arose afterwards. It arose after the order of the court on the receivership. Section 9.4C7 requires a ruling from the Minnesota court that the defense that they raised and that the equitable relief that they asked for wasn't going to be granted, wasn't merited. Can't bring it ahead of that. And I completely disagree with the idea that we knew everything for the fraud claim to have been brought in Minnesota. We didn't know a variety of things that we have now alleged. We didn't know that the estoppel certificate was forged, that the lease was forged, that the lease payments were false. There was a series of things that came to light over time. And my client, as the whole point of these guarantees written the way they are, doesn't have to wait to find out if there's been fraud before they secure their loan on secure the asset that they have a security interest in, which is the foreclosure. It's why these things are done this way. And finally, I just say Minnesota law, as y'all pointed out, Minnesota law allows you to bring a separate guarantee. They don't cite you a single case from Minnesota that says when you have a foreclosure, you have to bring the guarantee with it. All the cases say the opposite.
Thank you, counsel. Thank you all. Yeah. Okay. Yeah, so I'm not going to argue. Come on up on Paro Management. Please.
May it please the court. Good afternoon, Your Honors. My name is Mark Subcheck, and I'm here on behalf of Appellate, Allied World National Assurance Company. The evidence here is overwhelming that Allied World made a prima facie showing of entitlement to summary judgment, that Paro and JNN first received notice of the underlying lawsuit against them years before the Allied World policy went into effect. And we can go through that evidence. It's no less than 7 separate times that Paro and JNN received this underlying lawsuit. And the first was through formal service of process. Under New York law, properly
You
executed.
definitely got that. But then they have this litany of affidavits from various people who work at Paro saying, we never got it, we don't have it in our files, and so we were never properly served.
I would just simply point to the number of the cases that we've kind of sprinkled throughout our briefing, the State versus Cancom case, the Bettesy Imports case, the Williams case, 18th Avenue Realty Corp, HSBC Bank versus Gifford, all of which say that mere denials are not enough to overcome a presumption that arises upon service of process or proper mailing of an item. I mean, here, the most salient evidence is their receptionist, Teresa Ricciardelli, signed return receipts that established the summonses and complaint were served on, I believe it was in March of 2018.
2017.
I'm sorry?
According to the document examiner, it was 2017. Is that wrong?
That would be the summons and complaint. A year later, the underlying plaintiff's counsel sent default letters attaching the summons and complaint, and he sent them via certified mail. The return receipts came back signed T. Ricciardelli, which is Teresa Ricciardelli, which is Paro and JNN's receptionist.
And then you got an expert to verify her signature, which they fault you for because you didn't ask her about that at her EBT. Now, is that something you're vulnerable on?
I don't think so. I think it's the handwriting experts report speaks for itself. They had ample opportunity and discovery, and they didn't take it.
Was there a rebuttal to the handwriting experts?
No.
I don't know what you would call this. I'm looking at the document at 411. So report, I guess?
It's a report. There's nothing in the affidavits that Paro and JNN submit in opposition to summary judgment that rebuts that handwriting. It's actually because those affidavits are all dated 2021. They were the affidavits that Paro and JNN submitted in order to vacate the default judgment against them.
Right.
Was a hearing required for service here? Should there have been a hearing on service?
A hearing of service?
Proffers hearing?
I
the
don't believe so,
underlying
no. I think that I think that the evidence is ample even without service of process that they had. We don't need formal service of process in order to show that a claim was first made before the policy incepted. We can do it with the return receipt requested. We can do it with the 6 documents that underlying plaintiff's counsel sent. He sent a motion for default judgment. He sent that in 2018. He sent a notice of pendency of action, notice motion to renew default, notice of entry of default, note of issue. I mean,
The record keeping below was pretty interesting on behalf of counsel for the lead exposure, the lead paint plaintiffs.
yes.
Yeah, it was pretty meticulous.
It certainly was, and it was, and Allied World's thankful for it.
Now, the parties in that underlying suit did stipulate to vacate the default. Do we make anything of that? Does that mean anything to us?
I think that you can chalk that up to, there could be a multitude of reasons. One, it could be that maintaining a default hands Allied World ammunition, where an insurance carrier, that could be part of it.
Outside the record, of course. Okay.
Outside the record, of course.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Evan Schwartz, Conroy and Hack for Respondent, J&N Realty and Parallel Management. Again, we're looking at issue finding, and we're talking about whether or not there is a question of fact. And when you look at the 4 affidavits, whether or not you use them in the context of the vacature of the default, both of the courts below who considered basically the same evidence and found there was a question of fact. And it is not just naked bare allegations. It is detail of all of the people who were involved in the process at this realty management company and this realty ownership company, who regularly receives process, who regularly tenders complaints to their carriers, and it's part of their business.
But you know that a mere denial of service isn't enough.
This is more than just a mere denial of service. It is a mere denial. It's a denial of service in conjunction with an explanation of how procedures work in the office and a full and complete search of every part of their file, including emails and documents that were, the affiants explained that they could not locate any of it.
What do we make of the report of the document examiner who said, the signature on the green cards, the return receipt requested cards, is the same as on Ms. Ricciardelli's affidavit? There was no rebuttal. There was no expert.
There was no rebuttal expert, but again, no one was, Ms. Ricciardelli was never even asked whether or not that was her signatures.
How is that dispositive?
It's not, but it's a question of fact for a jury to weigh whether or not that means they had notice.
It could be mere strategy. I'm not going to ask her the question.
We don't know. We just the record stands the way the record stands. But Ms. Ricciardelli, as well as Ms. Alduano and Ricciarte and Mr. Schwartz all have said they're the ones that get all these documents. They're the ones that process them. They're the ones that tender them. That Ms. Ricciardelli merely receives it and then hands it to someone in the office. And there was detailed affidavits of how they work, and that none of it was there, and none of them, and all of them were there from the period of 2017 through 2020, when all of this, whatever happened, and all testified consistently that the first time they learned of this is when it showed up on a list pendants report, when I suppose that the respondents were looking for a refi.
And that's your position for showing that you have defeated the presumption of proper service and mailing?
Rebutted the presumption sufficiently for a credibility determination to be made by a jury, Your Honor. If there's nothing further.
Thank you, counsel.
Thank you.
Very briefly, Your Honors. As far as the deposition of Ms. Ricciardelli goes, both sides were there. They could have asked the question too. And as far as those affidavits, there's nothing in them about the green cards. Ms. Ricciardelli doesn't dispute. There's no evidence at all anywhere in the record disputing that she signed it. Even expert aside, it says Teresa Ricciardelli on it, and it came with the summons and complaint via the default letters. I don't know what more a move-on would have to do to make a prima facie case than Allied World did here.
Let me ask you something about chronology.
Yes.
So if she's not asked at deposition, is this your signature or not? Or were you served or not? If she's not asked that, and then you have a subsequent affidavit in time and there's a gap in time, then is there an issue of fact, or does that document examiner's report destroy the testimony and the affidavits?
I think that the document examiner just made a simple, the affidavit from 2021, lined that up with the green cards and said that's the same person. That's all the document examiner, the handwriting expert did. And I don't think it necessarily destroys anything. I think it's people's signatures don't change. I would assume that people.
So you're saying it's an A1 situation?
I'm sorry?
A 3211, I'm sorry, this is a motion for summary judgment
It's
to
a motion for
dismiss.
summary
So
judgment.
3211A1, like, based on documentary evidence, this should be dismissed.
We moved on summary judgment. I would maintain it. It's a summary judgment motion, Your Honor. Unless Your Honors have any additional questions.
Thank you, Counsel. You're in from Illinois, are you?
I am.
So stay away from Katz's Delicatessen on weekends. And if you like dumplings, I know dumplings are big in Chicago, go to Jackson Heights and have Nepalese dumplings. There's like Nepalese dumplings from all kinds of cultures there.
Thank you for the.
Your partners want you back, but just in case.
Great afternoon, Your Honor.
Have a good one.
Be well.
Thesuza from the Hudson Yards Construction.
Somebody left a paper.
Oh, Counsel, did you leave?
Oh, I'm sorry. Thank you.
Thank you.
Doesn't help me, so. Good afternoon, Your Honors. May it please the court. I'm Lisa Como for the plaintiff appellant. So reasonable justification or excuse and due diligence are essential on a motion to renew, especially when that motion is made after the order you're seeking to revisit has been affirmed on appeal, as is the case here. In issuing the order appealed from, the Supreme Court found that the justification for not coming forward with the affidavit of this non-party witness, which we submit should have been done a long time ago, the justification was that the court blamed the plaintiff for not disclosing the identity of the witness and thus somehow making it.
Well, Mr. Silva did say that he knew the plaintiff was friends or was acquaintances with his own father. Is that right?
No, that was crossed out. That was a sentence in his affidavit that was crossed out. We don't know who drafted the affidavit or how that came about. That was not disclosed. But the only thing, so plaintiff testified, and it's unrefuted, that he did not know whom the identity of the person who had translated for him. He didn't know Mr. Silva. He was some coworker who was called. He wasn't working with him at the time. He was called in by the manager. The plaintiff went to the office seeking help for his injury, and they had like an on-site medic.
Let's agree. Let's agree on that. How's that?
Sure.
Let's start from that point. To the extent that the plaintiff was unable to give a name, identify the New Leaf employee who did the translations into Portuguese, right? What problem is it with allowing testimony or an affidavit from that person to come in at the point where that person is identified by the defendant?
Well, it's a motion to renew, so that information existed a long time ago.
How do you know?
Well, he was a New Leaf employee, and according to the testimony that was taken from the defendants in 2021, so plaintiff testified in 2020 that some coworker had translated for him. In 2021, there were defense depositions, and it was disclosed that the project is still ongoing. New Leaf is still on the premises doing punch list and other work. The general contractor could have found that out quite easily at that time.
Okay, so what year are we talking about?
in 2021. The plaintiff disclosed in 2020 the existence of the translator. In 2021, there's testimony that the employer, the company, New Leaf, the project is still ongoing. They're still on the premises. They have made no showing that first of all, it wasn't kept from them by the plaintiff because he didn't know this man. This man only said he saw the plaintiff in the neighborhood at some unspecified time, not that they ever spoke.
Counsel, isn't it true that the reason that the witness didn't come forward, Mr. Silver, if you look at paragraph 10 of Mr. Silver's affidavit, record 1354, is because he had concerns for safety?
I think that's a red herring, Your Honor, because where is the explanation? He doesn't say he had concerns of safety from the plaintiff or from anyone acting on behalf of the plaintiff. Perhaps he is undocumented and his concern was being deported. But that's all part of the showing that they were required to make.
Why isn't that a reasonable showing if a non-party refuses to cooperate and then later, for some reason, it may be that it wasn't the plaintiff that did anything wrong, but even if it's immigration status, is willing to come forward later?
But, Your Honor, there's no showing that he had refused to cooperate. All we know is that I submit, what we know from this record is that they should have been able to find him.
But
that he
that's not what the affidavit says. It says that at the end of 2024, I explained I was unwilling to cooperate with him. We're talking about the prior investigator regarding the lawsuit and appear for deposition trial because I had concerns for my safety.
Right. At the end of 2024, this appeal already had been decided. Summary judgment was already granted in favor of the plaintiff. There's been no showing whatsoever about what happened before that, when that all came about. This was all part of the showing that they should have made. And when you are looking at a motion to renew after an appeal has been taken, it's even more stringently applied. They could have come forward with him, and they never disclosed his name as a witness. It's not like they said, well, we know Rafael Silva is a witness because they could have gotten it from the New Leaf employment records questioning their own contractor. They never even disclosed him as a witness, which also is the basis for our cross motion to preclude him, because that's also just improper. Whether he was cooperative or not,
Address that
they
on
should have disclosed him.
rebuttal. Thank you, Counsel.
Thank you, Your Honor.
May it please the court, good afternoon, Your Honors. Christina Pingaro for defendants, respondents. So I understand the court maybe has some questions, but I'll launch right into it, so feel free.
Can I ask you that question as well? Because paragraph 10 does talk about 2024. What happened prior to 2024? Where is the record which would show what the defendants were doing from prior to 2024?
So prior to 2024, between the time of the original summary judgment motion?
From summary judgment to after the appellate division affirmed.
So it is a respondent's position that throughout discovery, normal discovery devices were used to try and identify the name of this person, his address, where he was located, any kind of demographic information that would lead defendants to the discovery of this person's identity so that they could speak with them. After the close
Counsel, you heard your opponent talk about why not just look at your employment records for this construction site? Mr. Silva might have appeared there.
Respondents had, as owners of the construction site, they were actively undergoing the discovery throughout this time prior to summary judgment. They had been doing their diligence in getting people who were principals from the other entities that were actually physically present on site to be deposed. They were asked who else was present on site. I think 3 or 4 different individuals from the site on the day, in fact, were deposed and gave information. Respondent defendants did everything that they could throughout the course of discovery in order to identify this individual who allegedly had translated.
Counsel, who says that?
I'm so sorry.
Who says that? Do we have an affidavit? Do we have a deposition?
So we just have the normal course of discovery. We have the information that was requested by the defendants during discovery.
The reason why I ask is because the information that's offered by this person is striking. And if you put it together with the medical records, where essentially the information that's supplied is that this person did not have an accident which involved a what?
The yo-yo.
Right.
Yeah.
The yo-yo effect of slamming against, right. I mean, I was on the earlier case, as you know, the earlier appeal. This person says, and Mr. Benvindo Arujo Silva he says, no, the problem was a damaged, what, finger?
Correct, Your Honor.
And not a damaged body.
So Your Honor is correct that the information provided ultimately by Mr. Silva was striking and in fact was not the information being sought by defendants for the purposes of identifying this translator. It was accidental information that was discovered when defendants finally identified and sat down with this person, and it was that specific information that Your Honor has identified that compelled defendant respondents to seek renewal of the summary judgment motion, as that shocking information certainly raises tribal issues of material fact as to whether there is any applicability of the labor law here, which is exactly the reason the defendant sought renewal in the first place. And the trial court, in its discretion, took this piece of information, said that certainly raises a tribal
Have you prejudiced the plaintiff? Is this a delay that has prejudiced the plaintiff?
Certainly not, Your Honor. Certainly not originally, and certainly not at this point. For if trial goes forward as scheduled in June of this year, plaintiff will have had 14 months with the identity of this person, the affidavit, and the information that he possesses to prepare for his cross-examination at trial.
Thank you, counsel.
Thank you, Your Honors.
Your Honor, I think this is one of those cases where the delay itself is highly prejudicial. This accident happened in 2019. As we've been discussing, using a normal discovery device, what that translates to on this record, as far as I can see, is they served a demand for witnesses and they didn't get his name back. I would have to double check to be absolutely sure, but when Mr. Felipe testified, for example, he's the witness who said the project was still ongoing and New Leaf is still on site. I don't believe there were any questions about the identity of the translator asked of the witness.
Did the plaintiff testify that he did not know the name of the person that translated for him?
That's right, he did not know him.
How would defendant know if that was the case?
The defendant was actually in a much better position to identify him because he was an employee of their subcontractor. They're one of the defendants is the general contractor, and the contractor who employed the plaintiff and also this gentleman were still working at the site at the time Mr. Felipe, one of the witnesses, said that was still ongoing. They've made no showing that they didn't try to reach out. I mean, a discovery device is not, in a formal demand, in an action, is not the only way to find out the identity of a witness. Where is the affidavit from the investigator? Where's the affidavit from somebody who...
I understand you're saying that not knowing about Mr. Sousa's existence prejudiced your case, but then the hospital reports and the MedRight urgent care records also...
Mr. Silva's existence.
Oh,
Sousa's
I'm sorry,
I
Mr.
understand what Your Honor
Sousa.
is asking. Mr. Silva.
Silva, sorry, Silva. Amdino Silva. It corresponds with what Mr. Silva had said.
Yeah, I actually disagree, if I may just jump back for a second. I don't think that what he said was so shocking, and this was discussed at the time of the prior appeal. The defendants had argued, and it was hearsay in the prior appeal, and now they're trying to come in with Mr. Silva saying, yes, I was the translator. But what happened was that Mr. Thesuza, he injured his finger with the crowbar in the course of falling from the unsecured plank. That was his testimony, and he went to get medical assistance, and it was during him speaking to the medic that Mr. Silva was translating for him. That's the testimony from Mr. Jovinko, who is the New Leaf supervisor, who couldn't understand Mr. Thesuza. So it's during that conversation with the medic, when the man has a finger that's broken in several places, that he's explaining how he hurt his finger. I don't think there's anything shocking. Is it incomplete? Does he also allege that he had complaints about his back and his knee?
Yeah, counsel, but he also, Mr. Silva also says that contrary to Mr. D'Souza's account, he did not go with him to MedRight. And the MedRight records also do not reflect a translator, correct?
Right. That seems to be the case. I mean, I don't think that proves anything, but that there was no translator. We don't know. Maybe they tried to use Google Translate. I mean, that might be an open question. But again, the fact that a description is incomplete, Mr. Thesuza also testified, and it's unrefuted, that when he went to MedRight, he only got treatment for his finger, and they told him to follow up with his own doctors for anything else. Basically, it's an urgent care place. He has a broken finger. That's the most emergent thing. Was he walking? Yes. He
went back twice to MedRight, though, right, after his initial visit?
Follow up for the finger. That was, yes, to follow up for the finger. But his testimony was then he received treatment elsewhere.
Do we have two different versions now of how the accident happened?
I don't think so, Your Honor. I think all we have is a less complete version, which is focused on him getting treatment or seeking help for his badly fractured finger at the very moment after the accident occurred, and then a more complete description at a deposition. I don't think there's anything necessarily inconsistent about that. Nothing that Mr. Silva has to say contradicts. And if I may just very
Wait.
quickly.
So if nothing if there's no contradiction, then you're not prejudiced.
I understand what you're saying, but why? But this is.
No, I'm asking you. If you have no contradiction, then there's no prejudice, right?
Well, meaning that it doesn't change the prior result. In the context of a motion for renew, not only is there the explanation and diligence required, but it would have changed the prior result. So if there's no contradiction, it wouldn't change the prior result. The fact that we know that he did hurt his finger with the crowbar. He said that. It's a less complete description. And if I please may just have 30 seconds more to address one last thing, and it's in our briefs. We have an affidavit
I'm
from
sorry, I've let you go on quite a lot longer. Your brief is excellent, and so is your opponent's.
I just asked the court to look at the part about the non-party witness and their attempt to impeach him on appeal.
Thank you,
with
counsel.
material outside the record.
Thank you both.
Thank you.
Thechecko v. Tishman Construction.
May it please the court, Glenn Kaminsky with the firm Morrow Lilling Party Counsel for the appellants. The Court of Appeals has ruled that for 240 sub 1 liability to exist, there must be both a statutory violation and that violation must be the proximate cause of the injuries claimed.
It's also ruled that there can be more than one proximate cause of an accident, correct?
There can be more than one proximate cause of an accident, absolutely. But in this case, there's not more than one proximate cause of the injury alleged, the impact with the ground. Mr. Piscani testifies.
Could he have suffered other injuries even if his lanyard was attached and worked?
We could speculate that he could suffer other injuries, but
would he have fallen to the ground if the lift didn't catch on something and caused it to shudder and eject him into the air? I mean, that was a cause that he was. I agree with you. It's good public policy that workers use their lanyards on construction sites. However, it's also good public policy to have lifts that work properly and don't become a probable cause of, a proximate cause, a little late in the day, of an injury.
Well, it's not a proximate cause of the injury. It's a mathematical impossibility with the length of the lanyard, the size of the bucket. The testimony of Mr. Piscani clearly indicates that this man could not have fallen out of the bucket further than 30 inches below the bucket if he had the lanyard. Yes, the
Let me
bucket.
just clarify one thing. The lanyard was not one of these ratchet type lanyards, right? It was a finite length of.
It was 6 feet, yes.
And the testimony is that he would have been suspended.
Suspended 30 inches from the top. He would have been above the bottom. That's 454 of the record.
So what you're saying is that he most likely would have been injured, but he wouldn't have died.
None of the impact injuries, and that's all we have here, are impact injuries, would have taken place.
Because he fell down.
Right. But at worst here, the jerking of the bucket, if we agree that even happened, and that's a whole nother issue, that at worst created the conditions for the injuries to take place, but were not a proximate cause of the injury because the plaintiff, had he not detached himself, would have never hit the ground. And under the facts of this case.
So, counsel, isn't there a case from the First Department that's cited by your friend Delaval that says that this particular situation, when someone is in a bucket and then there's a sudden drop of that bucket, that alone gives rise to liability under 240 subsection 1?
There are cases, and we distinguish the cases in our reply brief, like Delaval, like Harjo, Cobb, all right? But the difference here is that we know from Piscani's testimony that the injury could not have occurred.
No, Piscani said also that at the very least, such an occurrence would have ejected the plaintiff out of the basket, thus implicating 240 sub 1. That's all a plaintiff has to show in a 240 case is with inadequate device. And Delaval says that a basket that comes to a sudden halt and you fall out and you get ejected is 241 liability.
And I'm going to say respectfully that that is not the law. That the law here is that you have to have a proximate cause of the injury. Delaville talks about the accident. The accident is not the problem here. You need to have proximate cause of the injury, and this injury could not have occurred and certainly couldn't be determined as a matter of law on proximate cause, where this 6-foot lanyard has to go over, where if he had worn it, he could not have impacted the ground. These are solely impact injuries.
Thank you,
I will
Counsel.
wait for a reply.
Good afternoon, Your Honors. May it please the Court, William Kazmierczak for the plaintiff's respondent. The purpose of a lift is to bring them up to an elevated surface and bring them down. This lift failed that poor purpose, and the injuries was approximately statutory violation.
Work is sort of can be inherently dangerous, Counsel, and shouldn't there be redundant safety measures on work sites? And here there was one, and it wasn't used.
But the statutory violation lies within the ejection. The testimony from Piscani is whether they were tied off, not tied off, they were going to be ejected from the basket. And that's a statutory violation, and the plaintiff cannot be the sole proximate cause where there is a violation of 240.
So I'm looking at my summary of the testimony of some of the witnesses. Mr. Pinotti, the Tishman superintendent, says that after both men were on the ground, because he did not see the accident per se, he saw the boom lift move unnaturally at a very fast pace, moving up and down. Mr. Squalls, who was the decedent's co-worker, he said that they felt a big jerk and a bang that when the basket of the lift apparently made contact with an obstruction that perhaps was a stanchion that was there. So, and that he felt the speed quicken. He felt a force as if something was pushing. Mr. Piscani, the general foreman, said that, as my colleagues have referred to, that not only would the lanyard have stopped them, the two men from being ejected, but also that several people found a piece of stanchion that had broken off, and that there was an impact mark on the boom. So have you established, have you provided enough evidence? Have you met your burden to have liability found in your favor on a motion for summary judgment?
Yes, Your Honor. Based on all of that testimony, it shows that the lift struck an obstruction, a stanchion, and it caused the ejection of the decedent. And we feel the lower court probably decided this motion in our favor.
Is it that simple?
Yes.
Is there any dispute that even if he had the lanyard on, he would have been ejected anyway?
There's no dispute. He would have been ejected whether he had it on or not on. If there's any other further questions, thank you.
Thank you, Counsel.
So, Counsel, you haven't, hello.
That's okay. It's your show.
Sometimes. This issue of the stanchion you did not address. The issue of an obstruction that apparently interfered with the descent of the basket. And to my knowledge, you don't have an expert who says, nah, that didn't make a difference. The lanyard would have saved the day. Nobody would have been, it would have stopped the people from being ejected. See, that's the part that you haven't talked about. You've talked about the lanyard stopping the people when they were ejected, but you haven't talked about the act or the act of being ejected. And the lanyard wouldn't have stopped them from going up in the air.
Your Honor, for the purposes of this appeal, I will concede that they were ejected from this bucket.
And therefore, don't you fall into the category of more than one proximate cause?
No.
As my colleague pointed out at the very, very beginning.
Because the proximate cause of the injury is an impact with the ground that could not have happened if the lanyard were attached. That's why.
It doesn't make any sense.
Well,
First,
what the
first,
law
no,
is.
pero, sorry. You know, when I get upset, I speak Spanish instead of English, which is terrible. But the first action, the first event is the ejection. And then the second event is the lanyard or the non-existent lanyard. So you're jumping from A to C, but you forgot B.
But respectfully, I have to say that that's not true, because the lanyard is there to keep him from hitting the ground, okay? If there were injuries because he got ejected, used the lanyard, and we had strain injuries or something, I wouldn't be here, right? I'd be arguing there's strain injuries.
That sounds more like contributory negligence. This is akin to saying the ladder was defective, but he wouldn't have been injured had he worn a hard hat or something. I mean, your ladder is still defective, so your bucket is still defective, which caused the worker to fall.
Well, the difference here is that we know from the testimony that the impact with the ground couldn't have happened. It's not just the hard hat. The hard hat would have only protected his head.
I figured it out. The
He
issue
couldn't have hit the ground.
No, the issue is that irrespective of what type of injury resulted, the bottom line is that there was an ejection that resulted in an injury. In one case with the lanyard, most likely perhaps it would have been not fatal. Without the lanyard, that was that. I mean, the other person survived, but that was that for
Right,
him.
but without the lanyard, it's not the violation of a bad lift, which is what learned counsel's saying here, right? We have a bad lift, it did something wrong, the lift was wrong. But that's not the statutory violation that caused the injury, because there was a lanyard to protect him, and the absence of using that lanyard was the proximate cause of the injury. Okay, if we had strained injuries, strains and stuff,
And I'm
if there's an order,
thinking of the basket. I'm thinking not of the lanyard. I'm thinking of the very beginning, you know, like in the beginning. The basket.
right, but that's but for causation, which we argue in our reply brief, right? But for this jerking of the basket, right, the accident couldn't have occurred. But the injury is what we're talking about here. Rokovich talks about the injury. It's not just a statutory violation. You have to equate the violation with the injury. And the only reason why, the superseding intervening cause, if you will, is the plaintiff's failure to use the lanyard.
Counsel,
And
you
it-
say that very well in your brief. You say it in your first page of your brief and throughout. So thank you very much. I think we understand the point.
Thank you very much. Thank you all. I appreciate it.
Thank you both. Hoben v. FCA US LLC et al.
Oh, my.
If you like, that's fine. Sure to put it back. Thank you. Please.
May it please the court. Melanie Fry with Dykema Gossett on behalf of Defendant Appellant General Motors LLC. The lower court here erred by failing to grant summary judgment for GM for this reason. The plaintiff's claim that we defectively designed our 2016 Acadia is based on the crash in this case being similar to an IIHS test, a test run by a private organization where they take a vehicle, they run it at 25% of the width of the front of the vehicle into a rigid barrier. That barrier goes all the way to the floor and
An
up.
SOF collision is the most common kind of collision, correct?
Correct?
Okay, so given that GM reassessed how it should deal with the front end of the Acadia on the Lambda platform in 2011, and then started to do that and then made some progress, but decided not to go forward with any retrofit of any kind. Isn't that enough to create an issue of triable fact concerning the whether this car was crash worthy?
It is not, because there is no evidence in this summary judgment record that the SOF test protocol by IIHS had any relevance to the actual crash dynamics here. And plaintiff's whole theory is that. Their whole theory is the test. Their test, as Your Honor just mentioned, or their theory is, well, GM, your vehicle likely would have failed under the test, and you made modifications later so that later iterations and later chassis would get better ratings on that test. And in fact, your later model did perform better on that test.
So I'm not understanding you. So there were efforts by GM to, between February 2011 and April of 2013, to improve the Acadia's ability to withstand SOF collisions, yes?
Yes.
And then there were changes targeted for the 2015 model year, yes?
For the 2017 model year, I
No.
believe.
That was a new iteration of the Acadia.
You're talking about originally,
I'm
yes.
talking about originally
Yes.
as a result of that testing and that analysis between 2011 2013. Was there a decision that, or a suggestion or a recommendation that the changes be effectuated for the 2015 model year?
I believe that's right. I believe that's in the
so.
record.
Yes. This vehicle that sustained the Acadia that sustained the crash, the collision, was a 2016 vehicle, correct? And then the actual change, the iteration, was effectuated in 2017.
Correct.
Right? So isn't that the beginning and the end of this?
It is not, because this was not an SOF. This crash was not an SOF. You may say, well, so says the plaintiff's expert, Mr. Herbst, and that's exactly my point. On page 10 of Mr. Herbst's affidavit, he has a one-liner, a conclusion, where he basically says, this is page 4376 of the record, he basically says, yeah, the test and the crash, those are basically the same. What this court will not find in the record are any data, facts, methodology, or analysis establishing that that is so.
So which expert of yours says that? That's you. I mean, I don't mean to be personal, but you know what I mean.
Here's what the summary judgment proof is
No,
that
do
we
you
put
have
in
an
on.
expert who says what you just said?
We have the investigating trooper who says that. We have the report of the New York State Police Collision Reconstruction Unit. We have two engineers who are motor vehicle safety engineers, Whalen and Parmar. And so what is our summary judgment burden? Because we have to carry that first before it flips. So our burden under New York law is to put on evidence demonstrating the absence of a triable issue of fact. And under the Reese versus Volvo case, it says, it criticizes the defendant there. May I answer Your Honor's question?
No, go ahead.
It criticizes the defendant for failing to submit the testimony of an engineer or an expert. Here we have two engineers. We have basically undisputed testimony from the New York police and the investigator saying, here's what happened. A Dodge Ram came over the top of your SUV and crushed it. And so we have that evidence. What we don't have from the plaintiff is them taking on that crash evidence that's in the record and saying, that's basically the same as the test, and then all of their evidence flows from there. So if they can't establish that substantial similarity, there is no evidence to support a design defect.
Thank you, counsel.
Thank you.
You have time, rebuttal.
Good afternoon. May it please the court. My name is Richard Montez. I'm an attorney with the law firm Memorial Ellington Party. I represent the defendant, FCA.
I have to ask you a question before we continue, because following up on what she just said, and I know you have a different client, but the state police said that the Dodge Ram veered approximately 1 foot into the GMC lane at the time of impact. Do you understand that to mean that the car went over the top of the truck?
I'm going to defer to counsel on that question because
Okay,
our issues don't
fair enough. You have a
impact
different
whether or
issue.
not how it happened.
Okey-doke.
Correct. Because our issue is about the wiring, right? And
yes.
Okay. So the plaintiff and the lower court said that this case is like Hoover. It is not like Hoover. In Hoover, there was direct firsthand testimony from the owner of the product from the beginning of the time that they used the product to the time of the accident. In Hoover, there was firsthand direct testimony that within 2 to 3 years of using the product in a normal and foreseeable way, the shield broke. There was firsthand direct testimony that in those 2 or 3 years, or end after, when they tried to replace it, when they tried to fix it, when they tried to repair it, it couldn't be repaired. And there was first...
In this case, you have Mr. Hanneman's testimony that it's a design defect to place the wiring where it was placed in the car, and that caused it to degrade faster than it wouldn't have otherwise. Why doesn't that create an issue of tribal fact with respect to FCA?
Because that entire opinion is conclusory and speculative. You cannot, there is no way that you can reach that conclusion based on the facts that are in this record. This vehicle had 201,000 miles on it at the time of the accident. There were 2 reported repairs that occurred a year and a half to 2 years before this accident occurred.
I guess their argument is that the repairs were necessitated by the design defect, that they were accelerated by the design defect.
It's an assumption that it was by the design defect, but this is a vehicle that was 201,000 miles. As Hoover says, products aren't supposed to last forever. This vehicle had been tested to standards of 125,000 miles. When he purchased this vehicle secondhand, it had about 75,000 miles on it already. So when did this occur? That's the problem that they have.
Doesn't a jury have to figure that out?
Not if it's impossible or incapable of being drawn from the facts, and that's the issue that
We saw the photographs of the spliced wire. So, but is that really the issue? Is as to the repair? Is the question the repair, or is the question the fact that, as my colleague pointed out, that it happens, that the wire frayed, was no good? I don't know what you want to call it. Decomposed.
The question is, why did the wire wind up like that? What necessitated the repair?
You think we can do that on paper? You think judges can figure that on paper?
Yes, just like you did in the Richards case, where there was a conclusory affidavit from their expert. This is the same thing.
Don't we have conflicting expert opinions with regard to this?
You do, but the question is can they actually reach the conclusion he's trying to reach? And you can't. So let's look at this car, 201,000 miles. If cars are not required to last forever, and this car had been tested up to 125,000 miles, when did this occur? Did it occur at 130,000?
How do you address Mr. Hanneman's argument that the sensor wires lack shielding, and therefore the regular course of driving, even minimally up to even 30,000 miles, would affect the sensors?
Because again, it's all an assumption as to when this occurred. If this occurred at 150,000 miles, there's no
but that's not my question. My question is no shielding at all. So it could have occurred very early on, and as my colleague said, that would be a triable issue for the jury to decide.
I just want to answer your question. If it had occurred early on, then the vehicle would have worked exactly how it was supposed to work. There would have been warning signals that would have told them that the system was no longer operative. They would have brought it in.
How did you address that there was a lack of shielding? I understand your argument that it was 200,000 miles, but initially there was no shielding it became vulnerable to the elements because of the lack of shielding.
The argument that they're making is that there should have been a different kind of protective coating, not that there was no shielding.
Counsel, we have another question for you.
Yes. Was there FCA evidence that the wires of some of the Dodge Rams that underwent testing had to be replaced at low mileage?
So this may take a few seconds, so may I answer? You want me to answer it now or on rebuttal? As much time as you need. Well, I don't want to say that to any lawyer, but anyway. Do what you have to do. So I'd like the court to, when it has a chance, look at page 3942 to 3946 of the record, and in particular, look at page 3943. That page has one of the notations that they're relying on, one of 5. That page at the bottom right, it says, this is page 55 of 63, and the notation is on line 836 of 840 other notations.
You know all of this by heart?
Yes.
Okay.
What does that mean? Because there's another 3 notations on another set of documents, that's pages 1 of 37, and they've only included up to page 22 that has 200 and something lines. So that means there are 5 reported instances of 1,000 that they've showed us. That is less than 0.01%. I may have gotten the math wrong, but it's not 1%, which underscores the exact point we're making. You cannot conclude it's more probable than not that this happened because of a frayed wire, when at best, all they've presented is that less than 1% of reports had this happen.
Thanks, counsel. Thank you. Have time rebuttal.
Good afternoon. May it please the court. My name is Jason Hartman with the law firm of Weinstein, Tippett and Little in Texas, appearing pro hoc vice on behalf of the defendant below, appellant ZF Active Safety US Inc., and arguing with the court's permission today on behalf of that entity. ZF Active Safety supplied a very important component in the Ram, the FCA vehicle that was involved in this crash, but it was only one relevant component to what we're here to talk about today, and that's the electronic braking control module.
What about the FCA's deponent? I forget the person's name, did tie you to the wiring, did tie your client to the wiring. Is that something we should disregard?
I think that is something that you should pay close attention to, in fact, Your Honor. I think that reference bears some careful examination. My colleague here has represented in the briefing, both below and in this court, that the FCA corporate representative testified that ZF was jointly responsible for the wiring in the Ram 1500. What that witness actually said was that FCA is jointly responsible with its supplier as far as the wiring goes. When we had the opportunity to ask that witness the same question, Mr. FCA, when you say the supplier, do you mean ZF? And he says, no, I mean the supplier of whoever the supplier of that particular component happens to be. In this case, for the wiring, ZF did not supply the wiring for that vehicle. That was a supplier by the name of Yazaki, I believe, and not ZF. And this was covered, again, in our briefing, both here and in the motion court below. So,
please continue.
So the motion court incorrectly charged ZF with responsibility for a component that it did not supply, essentially with the component being the wiring.
Maybe we should pivot then to talk about ESC systems working off of 2 wheels rather than 4 wheels, which is your other big point.
Sure, absolutely. So that brings us sort of into the proposed alternative designs, so to speak, which again, ZF challenged in its opening papers below, that the plaintiffs had not been able to identify any kind of feasible alternative designs as required under New York law. In an affidavit or affirmation declaration from their expert, the expert identified a handful of proposed alternative designs identifying vehicles by model year, by model and name. ZF actually supplied many of the systems that were in some of those vehicles and has firsthand knowledge about them, and again rebutted that testimony on reply with evidence showing that those proposed alternatives also had either 4-channel systems, just like the subject vehicle did here, and every single one of them would disable electronic stability control if one of the wheel speed sensors was compromised, either the sensor itself or the wire that transmits the communication from that sensor to the braking control module that
Counsel,
ZF supplied.
didn't plaintiff's expert controvert that in saying that it's a possibility of doing a 4C to a 2C when the 4C fails?
I beg your pardon, Your Honor. Would you please repeat your question? I didn't quite hear.
Isn't the plaintiff's expert contradict what you just said, that it's possible to have a 4C system revert to a 2C system and it still be effective?
That's another good point, Your Honor, and I believe we did bring that up in our initial declaration in the motion for summary judgment below, where those any kind of a 2-channel system that relies solely on essentially doing some guesswork between independent wheels to determine what that speed might be. And I apologize, but
please go ahead.
I could finish answering the question. Those 2-channel systems would no longer comply with the current version of the federal regulation in place at the time that this particular vehicle was manufactured. The current regulation, FMVSS 126, and this again is covered in our briefing, does require that every vehicle be manufactured with an electronic stability control system that is capable of identifying wheel speed sensors for each of the individual 4 wheels and applying braking torque to each wheel individually.
Thank you, Counsel.
Thank you, Your Honor.
Time rebuttal.
May it please the court. My name is Matt Geyer. I represent the plaintiff respondent. With the court's permission, I'd like to address GM first. This is the first I'm hearing that this was not an SOF collision. It's never been disputed. They never argued it in the motion court. They haven't argued it on appeal. In the record on appeal, you look into page 346 and 349, and it said front left corner to front left corner. This was an SOF collision. GM failed to satisfy its burden in moving for summary judgment. They submitted not a single expert affidavit attesting that this vehicle was reasonably safe despite the fact that it functions poorly in SOF collisions. They submitted nothing about whether they were reasonable in abandoning the remediation project and continuing to sell this car for years knowing that it was unsafe in SOF collisions. They submitted nothing about the expectations of the consumer relative to the implied breach of warranty. GM's theory as to why they should be out of the case appears to be that when they designed this vehicle in 2007, it was considered safe under the then existing IAHS standards, which didn't consider SOF. And they got, at one point, the seal of approval from IAHS. However, the problem is that doesn't apply on product liability or in the automotive industry. The automotive safety is an evolving measure. If it wasn't, we'd be driving cars today that have no airbags. We'd be driving cars today that have no seatbelts. It's taken decades to get here. And 2011 was an inflection point in auto safety relative to SOF collisions, because the IAHS came out and said, now we're going to run a test.
Just to return to the other driver, Mr. Alves, he accelerated right before the accident, correct? Do we know how fast he was going? And the reason I'm asking that question, of course, is could any design have prevented this, terrible accident?
Well, all right, so we're talking about preventing the accident versus preventing the injury. Okay, so relative to GM,
In other words, if he was going 75 miles an hour, what car would have protected?
No, he wasn't going 75.
Okay, how fast was he going?
Prior to losing control, he was going around 55, 56. At the point of impact, his vehicle was going 46 miles an hour. Our vehicle was going 32 miles an hour. So that's not excessive speeds. And the delta V, which is the change in velocity, which means the change in velocity upon impact, was 37.7 miles an hour.
He was decreasing his speed at the time of impact, correct?
Well,
Alves was.
His testimony was he using the throttle to try to regain control and get back into his lane, which he apparently did to some extent according to his own testimony. That doesn't mean he was going faster. It had gone from, according to the black box, the CDR, in the 30, 50-something range down to 46 at the point of impact. But this has not to do with the GM end of the case so much. I don't
I'm just
think.
thinking from a higher level, that's all, about the accident.
But we have evidence that this man could have been saved. We have clear evidence of that. My point is they never established their burden of proof in moving with summary judgment. Their theory is that the vehicle was safe because in 2007 it was safe. 9 years later, they sell the same vehicle and things changed. 2011, SOF, now safety goes by a different metric. Now safety contemplates, because we know SOF, I think you said it, is a very common collision. They've known this since the 1970s, that it's responsible for a lot of fatalities and a lot of severe injuries. They tried to fix it. GM undertook efforts to try to fix it, and they made great progress. They had a mule test that got them from poor to acceptable. They had I-143, an FEM, a model that they predicted would have gotten them from poor to acceptable. And they had other measures, the elephant trunk, the high increase, the high strength steel.
No, you unpacked that series of events in your brief very
indeed.
well. You want to say anything more about GM, or can we go on to FCA?
The point is our expert applied the I-143 measurement reductions to this accident, and he determined that there's 4 A, B, C, D, okay, that's what they measure, from 31 inches to 10 inches at A, 30 inches to 11 inches at B, 26 to 10 at D, and 21 to 9 at C. That's a huge amount of reduction. Our expert in biomechanics said this would have saved the man.
Now, you recite that in your brief very meticulously.
Okay.
Let me ask you about, just pivoting to FCA for a minute. One point that you make about FCA is that there were 16,000 repair kits sold between 2018, 2023 for this wiring. Am I right about that?
Exactly correct.
Okay, but how do we measure that? I mean, how many repair kits were sold for bumper? In other words, how do we see that as an inference we should draw that there was some problem with the wiring?
Sure, the inference, my expert, Mr. Hanneman, said you wouldn't have sold that many. He indicated this is a large number. You wouldn't have sold that many if they weren't anticipating a high number of replacements. I mean, 16,000 for the rear speed wire. That's a lot under any measure of the whole thing. I understand what Mr. Montez is saying about the durability logs, that it's a small number. You had complaints of people who were saying they have this problem. One guy says, "Do I have to get killed?" You have the tread reports. You have everything. But most importantly, they didn't establish their burden of proof either. We alleged the defects about the wiring, about the fail-safe, about the warnings. All they put in is an affidavit from Tandy, who gives a conclusory statement. It's reasonably safe and it's not defective. He didn't address one single of our allegations about the defects. That's insufficient to establish their entitlement to summary judgment. Instead, he focused on this idea that there was a substantial modification and that was a defense. That doesn't apply here. It's not even close. Substantial modification, aside from the fact that it's got to leave the factory without a defect, substantial modification means you have a working, functioning safety device that was deliberately bypassed or destroyed. Case in point, the Robinson case. They cut a hole into the shield, a 6-inch hole, destroyed the utility. Here, you had a device, the safety device, ESC, and the wire that was not functioning. It was the opposite of a substantial modification. It was an effort to repair and make it function again. That cannot be substantial modification. Mr. Tandy never addressed the key issues in this case. Were there defects? Were there alternative designs? I didn't even have to put in Mr. Hanneman because they didn't satisfy their burden. But he comes in and he examined the car. He inspected the car. He said there was nothing else that could have caused this. He said there was no damage in the undercarriage that would have happened if there was an accident that caused the wire. The only thing that he can see that would cause it is because it's subject to the movement from the coil and the road debris because it's in front of the axle instead of behind it. And he says it has protection. It doesn't have protection. It's a copper wire with insulation. There was no protection here. That what they needed and what they subsequently did after they stopped working with ZF was that they put sheathing on top of it. That is protection. Didn't exist here. So we have all this evidence, and the only one who gave an opinion as to when this happened was Mr. Hanneman. And he points out there were 6 splices. He said likely did not happen. Well, it once happened over a period of time. Why? Because it was so vulnerable. So with that, and by the way, they basically conceded causation there because Mr. Tandy said if the wire's working, the ESC's working, no accident. Now, just to get to ZF, I cover it pretty good in my brief.
What about Tandy's premise that there's no exemplars of a 4-channel system, or rather of a 4-channel system being caused to reduce itself to a 2-channel system? Didn't Tandy say that?
He didn't say that on his initial papers. Mr. Breitner from ZF said that in his affidavit. What he said, he's the one who addressed the 4-channel. He said basically we're required to do 4-channel. Mr. Hanneman addressed that in his affidavit. Tandy didn't address any of the defects at all. I'm telling you, take a look. He didn't address them at all in his initial affidavit. Just to, if I want to cover the ZF before I'm done. Look, I cover it in my brief. They didn't satisfy what they have to do for the component manufacturer defense. They didn't establish that there were specifications that they adhered to or that they didn't know the plans. Mr. Breitner comes in. He says, we're the ones who designed the module, which includes the fail-safe. They're clearly on the hook for that, but this I really want to cover. It's important to me because I've been accused in the reply brief of misleading the court. I did not mislead the court. Page 1003 to 1004 of the record. That's where Mr. Belinda from FCA specifically testifies that first he says somewhat joint, then he says joint responsibility between FCA and ZF for the routing of the wire, and even more importantly, that ZF was aware. Now they come back and they say, oh, he wasn't referring to ZF. Yes, he was. If you read from page 999 of the record through the very top of 1004, there's no question. He is being asked the breakdown of responsibility between FCA and ZF. And he said that was joint responsibility and they're aware of the manner in which it was routed. The page they cite up to 107 was asked about who investigates the warranties on the sensor. And that was relating to the sensor manufacturer.
What about Council's claim that they did not supply this component.
They didn't supply the wire, but this is the point of the component manufacturer. They were involved in, according to the joint responsibility, had joint responsibility for the manner in which it was routed, which puts it on them, because it's not the wire, it's the manner in which it was routed that's a defect. A wire is just a wire, copper wire with insulation. It's the manner in which it was routed. It was up to FCA and ZF to put once they decided to put it in front of the axle instead of behind it, to put the sheathing on it. And that's where the testimony that I cited comes in.
Thank you, counsel.
Thank you.
Please.
May it please the court, I want to directly address your honor's question that you asked of my co-counsel. You asked about the override, and I certainly didn't mean to imply that the Ram fell on top of the SUV.
Oh, I'm glad you said that.
Here's what we know about the evidence of the accident. This was a severe crash where the Ram became a literal battering ram. It missed the frame rails of the Acadia, is what we're referring to. So it overwhelms and overrides this mid-level, mid-size SUV with higher energy, height differentiation, as you can imagine with the 1500 Dodge Ram, and at a different angle than the test. And so when we look at the evidence, I've mentioned the reconstruction unit report from the New York State Police and from Trooper Telfler. He says the Ram struck the Acadia outside the primary structural engagement zone and directly into the driver-occupant compartment. And so you have this override, this overwhelm of an SUV, not direct engagement with the structural components.
So plaintiff's counsel says, you never brought this up before. This is true?
No, it's not. Page, on quick review, page 4 and 5 of our brief, I'll read from it. We're criticizing those opinions rested on a fundamental analytical error, equating a real-world vehicle-to-vehicle offset collision, a type of frontal crash where only a portion of the front of one vehicle makes contact with a portion of the front of another, with a laboratory small overlap frontal barrier test. Then we go on and say it didn't exist at the time. But we are criticizing their inability to say that crash test, that SOF test, that's just like the crash here. So they can criticize, you should have known about the test, you were developing to try and get better ratings on the test. That's all of their evidence of defect here. That's what they hang their hat on. They're missing the premise that that test is substantially similar to this crash. And without it, they don't have evidence sufficient to withstand summary judgment. And that's why we ask that summary judgment order be reversed and that it be granted for GM.
Thank you, counsel.
Thank you.
Counsel stated we didn't make a prima facie case. The only evidence we had was from Tandy. We also submitted an engineer from FCA by Linda who talked about the millions of miles of testing that this vehicle went through, testing which they have never taken any issue with, testing which they submitted in response to our motion. They gave you all the testing. It's in the record. You could take a look at it. What's interesting about his response is I think he seemed to agree that just noting a couple of complaints doesn't meet or establish that there's a defect, because you have to look at the statistics, you have to look at the frequency, none of which Hanneman ever did. One of the records that he cited just now, 3951 of the record, where he says somebody's gonna get killed. That's a customer complaint, and the very first page, the very first line, that car was involved in an accident, a severe accident, and his complaints were about the repairs that were being done after that severe accident. I'll just finish by saying, you have to be able to draw your conclusion. So I ask this court to really look at the conclusion he's trying to draw, Hanneman. Can he say what he's trying to say when the vehicle is this old? Isn't it also possible, if not more likely, that this happened just because these parts got older? And if that's the case, there is no liability, and he cannot exclude that. He just assumes that he's right on the defect and that this must have happened because of the defect.
Thank you, counsel.
Thank you.
I take the joint responsibility for the wiring very seriously too, and I don't think that this court should overlook it, at least in part because that's what, in part, motion court below relied on in denying ZF's motion for summary judgment, was the assertion that ZF somehow shared responsibility for that wiring. To the extent that we heard about the deposition testimony that FCA's corporate representative testified about that responsibility from page 1007 of the record, the question, when being asked about the joint responsibility for the wiring, the question, when you say jointly, who are you referring to? Is it FCA and ZF? The answer, no. It would be FCA and the supplier of the component, which could be ZF or depending on what component we're talking about. And later on in the same deposition, the question, okay, we know that Yazaki supplied the wiring and connectors for this vehicle. The answer, yes. That's from page 1320.
You quote that in your brief too, I think. It's in your brief as well.
In the brief, yes, Your Honor. It's page 1 and 2 of our reply brief, and it also appears in our opening brief as well.
Thank you, Counsel. Thank you
Thank
all.
you very much, Your Honor.
Justice Hagler is recused on the next case, Blue River v. Gross. Please.
Thank you. May it please the court. My name is Dennis D'Antonio. I'm an attorney with the law firm of Wegg & Myers, and I represent the plaintiff appellant, Blue River Gems. The facts of the case are very simple. I know you've read the briefs. You don't need me to repeat all of the facts. But at the time the motion was made before the motion court, it was uncontroverted that the property had been wrongfully converted by Michael Gross Diamonds, Inc. No question about it, because Judge Cohen had decided that fact, and this court, in a decision, affirmed Judge Cohen's decision, saying exactly that. Best case scenario, Michael Gross Diamonds stole the necklace, or if he didn't steal the necklace, he ignored all the red flags, didn't do research of provenance, had no bill of sale. He knew that the ownership belonged to my client. My client had asserted that.
And for that reason, you spend most of your brief talking about alter ego theory or about piercing the corporate veil.
Well, that's correct, Your Honor. We say on that basis alone we pierce the corporate veil, but it not on the same theory as the alter ego theory, because what came out during the hearing, which is thoroughly set forth in our briefs, is the conduct that he then engaged in. The record has evidence of the fact that following obtaining the judgment against Michael Gross Diamonds in post-judgment discovery, he swore falsely that the corporation stopped doing business in 2016, that it had no sales, no assets, et cetera. At
When
the
did
hearing,
he find out about the judgment?
sorry,
When did he find out about the judgment?
from Judge Cohen,
When did he find out about the
Judge-
judgment against Michael Gross Diamonds?
he was Michael Gross Diamonds, so I presume that when he was represented by counsel, Judge Cohen's decision was in 2016. So at the time that decision came down, he, as I said, he had testified that he had no income, no revenue, the business wasn't operating. Yet at the hearing, what came out,
The judgment came in 2018, though, just to be clear, right?
Judge Cohen's judgment?
No, the judgment where the money was actually quantified. That was in
That's correct. That's
2018.
Judge Hagler.
Yeah.
That's right. Summary judgment on conversion was granted previously by Judge Cohen. Judge Hagler, we then presented evidence on damages, and he issued a decision on damages. But the point I want to make now, in the limited time I have, because most of my points are spelled out thoroughly in the brief, is we didn't have the tax returns. They weren't produced in discovery. Issues arose, and Judge Hagler, we made a motion to hold them in contempt for that reason. At the hearing in 2023 or 2024, for the first time, we were given the tax returns for 2014, 15, 16, 17, and 18. And when I had those tax returns, I discovered what I had not previously known, that contrary to his sworn testimony that he stopped operating in 2016, the tax returns showed that in the years following 2016, his sales were $6 million, and his inventory was $1.5 million or thereabouts. That was the status of the business, according to the tax returns, when Judge Cohen granted summary judgment. After that, all of a sudden, his sales go down to 243,000, then 47,000. And in any business that's selling inventory, if your sales are declining, well, your inventory is not declining because you don't have sales. At the time of the decision by Judge Cohen, his inventory of diamonds was 1,250,000. Then we get Judge Cohen's decision, and that goes down to 800,000, 600,000, 47,000, and then it's gone. So when he testified under oath, post-judgment, that the business stopped operating in 2016, had no diamonds, no inventory, he was testifying falsely, as later proven by the tax returns. We also have his testimony that was presented at the hearing that he engaged in a systematic scheme.
You can talk more about that on rebuttal, counsel, and you do talk about it in your brief as well.
Okay.
Yeah, but you're about to talk about the charitable giving, I take it.
All right, fair enough, Judge, thank you.
May it please the court, Mark Hines, Ofek and Hines for the respondent, Michael Gross. I'd like to back up one stage because there's a dispute here about the standard of review. And we urge that the standard review ought to be from the result of a bench trial. As we set forth in point 1 of our brief, this action really, and I have no other complaint about it, is properly brought under CPOR 5225 and 27.
Yeah, I mean, the Supreme Court took testimony. You know, I take the point on that. Yeah.
Okay. So I'll move on. With respect to
then it's a fair interpretation of the evidence standard.
I agree. I think that's the standard here, not a review of a
I'm not sure you win under even that one, though. So go ahead.
Okay. So with respect to the liability here does not arise from the conversion. They easily could have brought an action against Michael Gross personally, either on a veil-piercing theory or on an individual participation in an intentional tort by a corporation. They brought neither of those claims. This action wasn't commenced until 2020. The purported discovery of some kind of financial issues in 2016, 17, 18 has nothing to do with the fact that they knew that Michael, according to their complaint in the underlying action, they knew by 2016 that this item had been converted. The individual claim for conversion is time barred. So would and the veil piercing claim or the alter ego claim relating to that transaction is similarly time barred because it relies on the underlying claim. What plaintiff has is not that. What plaintiff has is a claim arising from the judgment into which the underlying cause of action merged, dealing with the alter ego status or alleged alter ego status of Michael Gross Diamond generally, but you can't revive or create a perpetual cause of action for conversion against the individual. You already have a judgment where the individual claim is barred. So we think that the judge.
Are you saying that once you get a judgment, you can't ever try to enforce it against the officers of the corporation against whom you have the judgment?
Of course you can. No, of course. I know. I said exactly the opposite. In point 2 of our brief, we're saying that plaintiffs' reliance on the underlying cause of action as a basis for alter ego liability doesn't work because that claim in and of itself is time barred. It can't be maintained, and it could have been maintained in the original.
Don't we enforce judgments all the time against people who are corporate entity or purport to be behind a corporate?
Sure, of course.
So isn't that what he's doing here? He's got a judgment. He's trying to enforce it against another party because he says the corporate form is not respected, in fact, was abused to create this liability of your client.
Not in reference to the act of conversion. Once the cause of action has been reduced to a judgment and has become time barred, your claim as the judgment creditor is you've abused the corporation generally. You didn't maintain proper corporate records. You didn't maintain the individual corporate status. You engage in transactions. There was commingling, that kind of thing. It doesn't speak. If a corporation incurred a liability for some wrongful conduct, and that was sufficient for veil piercing, then the underlying claim would never die, or at least to be good for 20 years for the judgment. All we're saying is that what plaintiff did not prove is a general alter ego claim which established that Michael Gross abused the corporate form. It's not inconsistent to say that the corporation committed a wrong as to.
Did you make this conversion claim below?
Sure.
You made an argument?
Absolutely. We pled the statute of limitations in paragraph 55 of our answer.
No, but did you say that they're trying to do an run around the statute of limitations?
Sure. There's a post.
That was down below, okay.
We submitted a post-hearing memorandum. It's at record page 2433, and point one of our post-hearing brief was exactly the point that we argued here. Plaintiff's veil-piercing theory cannot circumvent the statute of limitations for conversion. So we're saying that the veil-piercing, I'm not saying they don't have a claim. I'm saying they have to prove the thing that Judge Douglas said they failed to prove, which is a general abuse of the corporate form. And that has to be, because corporations commit wrongs all the time. It doesn't give you an alter ego claim against the individuals forever.
What about the allegations that he made donations to charity, that he paid for his wife's dental work, all through corporate checks?
Right. So with two things, Judge Douglas set aside the charitable contributions under the debtor-creditor law, and we didn't cross-appeal from that. I mean, the court said that there were certain transactions, but that did not do violence to the general idea that Michael Gross Diamond maintained its separate corporate identity. With respect to the shareholder loans, I think this is worth a couple minutes on.
You got 30 seconds.
Okay. I'll give you just one example because it came up in plaintiff's claim. There was a payment to the dentist. At record page 1667, there's several of them. I'm just identifying one of them because they were all treated the same. At record 1667, there was $5,000 that was given to Dr. Harry Ramrus, okay? And it was booked as a MGD loan, meaning a shareholder loan, effectively, a loan to a shareholder.
Hold on one second. A loan to the dentist?
No, a loan from the corporation, Michael Gross Diamond, to Michael Gross, meaning that the money was taken out of the company and given to a personal creditor.
Got it.
Okay, but it was booked in the internal books and records of the corporation as a shareholder loan. If you take a look at record page 1725, it shows the running balance of Michael Gross's individual liability to the corporation on that loan. At the time that November 3rd transaction occurred, the loan balance was zero. You see from starting in 2014, there's a loan balance of $2,001. He's taking small loans and paying them back.
So he's not charging personal expenses to the company's bank account because he's paying them back? That's the
correct, because he's
Okay.
maintaining
Thank
a
you,
loan
counsel.
balance.
Thank you
That's
very
why
Counsel, you've gone over
I
quite a
just
lot.
make one tiny
No,
little
actually not, sorry. Thank you. We have your brief, don't worry. Please.
If it may please the court, I'm not going to address the point that was raised initially because the reply brief that we filed thoroughly sets aside the argument that counsel is making. The law is exactly contrary to what he's saying. You can go back into any wrongful acts and those become part of the evidence to pierce the corporate veil. But I want to direct this court's attention to a few things. One of the things that the court mentioned, he used this corporation he essentially looted the corporation. His testimony was incredible regarding the charitable contributions. He testified unequivocally that I wrote checks from the corporation, this is after the summary judgment decision, to these charitable organizations, and they returned the money to me, less a commission, but to me personally. That's money laundering. That's taking money from the corporation through these fake.
Sound like charitable giving.
What's that, Judge?
You put charitable giving in quotes.
Yes, correct, exactly.
Counsel,
Your
I
Honor.
assume
And
that these aren't like $100 donations.
No, there were probably off the top of my head 60, 70, 80 checks to all different, I gathered, charities that had names that sounded like charities. And when I deposed him, and at the hearing, he admitted he was writing the checks in exchange for the money being returned, but he wrote it out of Michael Gross Diamonds, and the checks and the funds were then returned to Michael Gross. That's money laundering.
Is that enough to establish alter ego?
By itself, no, but in the context of everything else, he also admitted after the judgment, the summary judgment was granted, he paid himself $500,000 out of corporate assets. When I showed him his tax returns and his salary was $50,000 a year, so these were discretionary payments he was making to himself, he said, well, that's what the tax return says. That's not necessarily true. And shockingly, the court, adopted
I
that.
want to say that at a deposition, but anyway.
Sorry?
Generally, not an admission, one makes it a deposition.
No, I would agree with you on it, nor the money laundering, but it was really unavoidable testimony. I'm out of time, but the checks to the dentist.
30 seconds, counsel.
Okay, the checks to the dentist are irrelevant. That's a red herring. The disappearance of the inventory is huge, because if that inventory didn't disappear, you could have enforced the judgment.
You mean the diamond necklace?
Yeah, the inventory on his books and records. He lied and said the business stopped in 2016. At the hearing, the evidence was it continued, but in 2016, it had $1.2 million in inventory and $6 million in sales. That's when we would have been enforcing the judgment. And then over the next 2 or 3 years, it all disappeared. There's no inventory and no sales. Thank you
All
very
right,
much.
thank you all. Thank you both.